Good evening, everyone. I'll note that it is 5:02, October 27th, 2022. I call this meeting of the Certificate of Appropriateness Committee of the Raleigh Historic Development Commission to order. At this time, I'll recognize staff to call the roll.
Curtis Casefang.
Here.
John Reese.
Here.
Rob Allen.
Here.
Wes Tripp.
Here.
And Jordan Ryland.
Here.
Announce the presence of a quorum here today. Again, I want to welcome everyone to the October 2022 meeting of the Raleigh Historic Development Commission's Certificate of Appropriateness Committee meeting. My name is Wes Tripp, and I am chair of this committee. I would ask, I noticed most of you already have, but if you haven't, please come forward and sign in the attendance roster. Agenda and staff reports are available online, and a handout of the meeting procedure is available as well. The agenda and today's materials were properly published online. This is a city council appointed membership. This committee consists of residents of historic districts, architects, intern architects, architectural consultants, and contractors, as well as attorneys and historians, urban planners, and historic preservationists. At this time, I will recognize my fellow commissioners and staff to introduce themselves. We'll start with Curtis and just work our way down the line.
Okay, I'm Curtis Casefang. I'm an architectural consultant, resident of Oakwood, and I was on commission a while back. Did the DRAC committee for a while, and I'm back again.
My name's Jordan Ryland. I'm a local architect and Raleigh resident of about 15 years.
Raz, you want to go ahead and introduce yourself?
I'm not a member of the committee. I'm Francis Raspberry. I'm an attorney with the Raleigh law firm, and I'm legal counsel to the Certificate of Appropriateness Committee.
Again, my name is Wes Tripp, chair of the committee. I am an attorney, local attorney here in Raleigh, and also a resident of the Prince Hall Historic District.
My name is John Reese. I am an architect here in North Carolina. I live in the Glenwood, Brooklyn neighborhood.
I'm Rob Allen. I am a project manager, senior associate at an architecture firm here in Raleigh, and resident of the Boylan Heights Historic District.
I am Erin Morton. I'm a preservation planner for the city of Raleigh, and I have a master's in historic preservation.
I'm Colette Canane. I am also a preservation planner with the city, and I have a master's in historic preservation as well.
At this time, I'll entertain a motion to waive reading of last month's meeting minutes.
So moved.
It has been moved and seconded. Question before the committee's adoption of last month's meeting minutes. All in favor say aye.
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 Any opposed? Motion carries unanimously. Staff, do we have any amendments or changes that need to be made to the agenda before we approve? No. Great. Awesome. I'll entertain a motion to approve the agenda.
So moved.
Motion has been made and seconded. All in favor say aye.
Aye.
Any opposed? Motion carries unanimously. Staff, do we have any minor work applications in the last month?
We had 7 minor work approvals this past month.
Great. All right, we are now ready to move on and hear applications for today's committee meeting. Prior to the meeting, notice was sent out to the property owners within 100 feet of the properties in question. Legal ads was placed and signage posted at the site. Commission members received a copy of each application, staff reports, and were to have visited each property. Staff reports were made publicly available with the agenda as well. North Carolina law provides that major work applications must be approved in an evidentiary hearing and that persons have an opportunity to address an application if they desire. We are now ready to conduct the evidentiary hearing portion of today's meeting. Evidentiary hearings are conducted in a quasi-judicial format. During the hearing, the committee receives evidence to determine that proposed changes are not incongruous with the special character of the district or the historic property. We review this evidence against guidelines referenced in the city ordinance before issuing a certificate. Each application is heard in the same way as listed in the meeting procedure handout. The quasi-judicial format of the hearing requires that the committee members be impartial. The written staff reports are evidence presented just as any other evidence and were made available to the committee members, the applicants, and the public at the same time. If any committee member had reason to discuss specific details of an application before today, we will ask to be excused from hearing that application. There is no time limit on testimony, but repetition is discouraged. Because of the quasi-judicial format of our hearings, which is that the commission hears evidence and then judges whether the change is not incongruous, we are required by North Carolina law to affirm or swear persons that speak before the commission and offer evidence. All speakers will be affirmed at the beginning of each case. Staff will now be sworn or affirmed now for all cases on the agenda. Members of staff that will be presenting evidence today, would you please raise your right hand and repeat or agree to the affirmation? Do you solemnly swear or affirm that the testimony you are about to give on the matters on today's agenda is the truth, the whole truth, and nothing but the truth?
I do.
I do.
Thank you. All right, we're now ready to move on to our first case. This is an old application, COA 0074 2022 602 South Boylan Avenue. Are there any members of the committee who have an interest in this matter or otherwise feel that they cannot be impartial or fair in hearing of this case? All right. Hearing none, we will move forward. Who will be presenting on this application? I ask that you please come forward. When you do come forward, please state your name and address for the record up at the podium with the microphone, please.
Brooke Tate, 509 Burton Street.
David Maurer, 511 Cutler Street.
Sarah Baum, 602 South Boylan Avenue.
Daniel Baum, 602 South Boylan.
Thank you. And anyone who will be presenting evidence, would you please come forward so you can be sworn or affirmed? Do you solemnly swear or affirm that the testimony you are about to give in this matter is the truth, the whole truth, and nothing but the truth? And I assume the property owners are present? Great. All right, at this time I'll recognize staff to make their presentation.
Thank you. So as you mentioned, this is an old application. It was deferred at last month's meeting. The property is 602 South Boylan Avenue, which is in the Boylan Heights Historic District. The request is to construct a second story on a rear addition and remove a dormer. And I'll quickly go through these. None of these photos have changed since the last meeting. It's just an overview of the property as it exists today. Some new information was provided and was included in your packet. The staff concerns just built mass to open space. There are still some questions about how you will consider that. And there were some typical material details not provided that are included in conditions.
This time I'll recognize the applicant for their presentation.
Great, thank you. David Maurer, architect for the project. And neighbor, I want to address staff's concerns. I'm going to try to keep this fairly brief. I've done some additional research since the last meeting to address staff's concerns, and I've got a handout that I'd like to enter into the record today. All right, two main things. The first section, I went back and researched and found that lot behind was subdivided from lot 192 in 1948, and the structure was built in 1955. The period of significance for Boylan Heights extends to 1935, so that building is outside the period of significance. So now you go back and you calculate the built mass based on the original lot size, which you see the calculations there. 8,958 square feet was the original lot size. So in fact, now we have an existing built mass percentage of 38.9, and we're doing a proposed of 44.9. The result is a 6% increase, not a 15.4% increase. And I know there were some concerns before about, is that too much? Clearly, this is well within an increase that this commission has been approving for many years. The other thing I just wanted to address, because this was talked about at previous committee meetings, and I think has influenced some decisions before. And I don't know if you'd like me to read it into the record, but this talks about, there's been a lot of questions of how do you relate to nearby or surrounding buildings. And there has been, through many years, a discussion of, is it that we've clearly said that we can only do it within the district. And then it's become narrower and narrower until it's like surrounding. Does that mean the next 2 houses, 3 houses, the block face or whatever? There is North Carolina court case law that talks about you must take into consideration the entire neighborhood and the district, right? Not just the nearby houses. So as we know in Boylan Heights and many other historic districts, it's not a pattern that you can find. It was really, these lots were sold to developers, and we have plenty of blocks that were 1 stories next to 2 stories, and really it was up to the builder and the developer at the time to build. So I think you'll find many patterns in there. So I think we've proven, and we've given plenty of examples of built mass on lots of this size next to 1-story houses throughout the neighborhood. And so I think that hopefully that will address that concern as well. Other than that, I'm certainly available for, and if anybody wants to see the original plat for that lot, I've got a copy of the original blueprint from 1888. Otherwise, I'm available as well as the homeowners for any questions.
Thank you. Is there anyone present who wishes to speak in support of the application? Is there anyone present who wishes to speak in opposition to the case? Are there any members of the public here with questions or who wish to make comments on the case? All right, at this time, I'll recognize my fellow commission members for questions.
There's not been any changes on the design since we last saw it, is that correct?
That's correct. I think last time there was a dimension that was missing on the survey, and we provided that as 5.1 feet. But we have not changed the design because it appeared that we were heading in the direction of an approval. But I understand there was the questions about the built mass, so that's why I wanted to provide those additional facts today.
Hey, David, Rob. Well, first off, thanks to you and Brooke for adding the site plan. That made me feel a little better. It's on the first page. So that helps a lot. I think one of the things I've been struggling with the built mass, and I agree with generally your sentiment about the statements of it applying to the entire district, precedents, and that sort of thing. David, you did, I think you compared the increase of the proposed to the original lot size was the way I heard you interpret it. I'm looking at the guidelines. I don't read it quite the same way, to be honest, but we've had extensive discussion about the definition of built mass. I read it as the original structure to the open area of the site, not original open area of the site. It's a minor distinction, but the syntax, I just read it differently. I'll leave it at that. But I think a couple of things I've really been struggling with, and maybe you can help me with this, is that there's we're in the same neighborhood. There's a few areas where I know there are garages engaged with the house. The few that I can think of are sort of tucked around, and fortunately or unfortunately for your clients, it seems like it's in a very prominent location. I see it as I drive down Boylan. And so I feel like the extension over it is further, we're seeing an engaged garage, and I'm struggling with that. And then I will say, just on just a mass level, the length of the addition, it's very long, and it's in fact longer than the original principal structure. And this principal structure, I think, just has some of the most beautiful features in the neighborhood. Two really elegant bay windows. And so what I'm seeing is a very long, tall wall that's abutting a house that's broken up into a lot smaller features. And I think that's why it seems to me, or that my perception is, that the mass feels too large. And I'll give you a chance to respond, but I think that's why last time when we were presented the new material, I couldn't respond without giving it some thought, and so I was able to sort of collect my thoughts. So sort of a question statement, I know, but feel free to respond.
If I might add to that, specifically the guideline that we were looking at was 3.2.7, limit the size and scale of the addition in relationship to the historic building so it does not diminish or visually overpower the building. And specifically the right elevation, we kept on getting hung up in discussion on the height of that addition and how it extends out, and does seem to be more massive than the original. And part of what we asked for was perhaps some kind of reconsideration, something to apparently diminish the scale of the addition.
And, okay, thank you for your comments.
Sure.
Most of what was just said was subjective in terms of interpretation. And we've provided plenty of facts indicating other structures that were just as large as this. The issue of the use of the garage is not applicable here because we don't take into account the use. It's just a feature. So whether it's a garage door or open doors, it's not, the use is not applicable. What we have, in my opinion, proven is that there are plenty of examples of structures in the neighborhood within the period of significance that have had additions of this mass and size. And we've proven that they are close to property lines. We've provided plenty of examples that can support this case. I'm having a hard time trying to figure out why this, can we make it better? Certainly. As an architect, we can continue making it better. We've broken down the west side that faces the other side by creating an eave there so you don't have that two-story line. We added that to it. And we've broken down all of the pieces so we don't have a two-story facade facing West Lenoir. But I'm having a hard time finding a reason that this is incongruous with the neighborhood. And I think that there's plenty of facts to say it is. I was hoping that these additional facts, I understand precedent. I've been working with this commission for 30 plus years. I understand precedent, and I think this gives you now another fact to say that this addition is within 6%. And I think to your question earlier, Mr. Allen, about, I think it's point 11, I think it specifically talks about original lot size. So.
It doesn't. It says original built mass to open space. The open space is not qualified as original. I'm sorry.
And it also says on an individual site. I mean, I think he has a point. Now, just assuming we can get over that hump of the footprint change, the elevation change, I would love you to speak to that and take me through how, looking at that right elevation in particular, how this much addition doesn't overpower that much original structure.
Well, for one, it's set back from the bay,
okay,
so it's not in the same plane. It's a hip form so we didn't provide any gables, so there's not any 2.5-story elevations on that side. There's also the bay of on the first floor that breaks up that plane as well, and then there's the gable of the garage element that is breaking up the length of it as well. And then we hipped the back where it faces the west property line. And again, it's, we've provided other examples, and I don't have the addresses right in front of me right now, where there have been additions that were, I mean, Montford Hall is a good, Heights House is a good example of a fairly major addition on the back of a house that's very visible, right? And there are others in the, so it's, again, I'm saying that I think, could we redesign it until we get what you guys like? Probably so. My point is that this is an evidentiary hearing based on facts, and we've provided enough facts that there are other examples within the neighborhood that support this application.
Curtis, any additional questions?
Actually, one for staff slash Raz. I believe the guidelines are talking about making judgments in relation to well-related nearby buildings. And we've just heard testimony that we're to consider the heights of all structures in the district throughout. And those seem to be in conflict.
I'll respond to that, since you quote language that is really not directly apropos to this case. The nearby well-related buildings language is in the UDO.
Okay.
And that relates to height and setback.
Okay.
I don't think height is really the criteria now that you're focusing
No.
on at this moment. It's the massing and the relationship, the overall ratio of mass to site, as well as the percentage increase. Surrounding is not defined. Surrounding, that verb appears, that adjective appears in 3.2.12 relating to massing. It is not defined. Nearby, well-related is defined in the UDO, but that concerns height, so that's really not what we're talking about.
Yep.
The operative term is surrounding properties, and I think that probably gave rise to the applicants concentrating on some examples that are in the immediate neighborhood as opposed to a broader scope. The overarching legal issue is congruity with the special character of the district. So you all are obligated to consider all competent material evidence that relates to that legal issue. So you can't narrow your focus only to the three examples they cite, or just, if there had been other evidence of other sites, you couldn't just look at those particular three buildings. We're of the opinion that the Mears case that was cited doesn't implicitly invalidate. There's just not enough there. It's distinguishable, and the guidelines are presumed to be legal and such. You are obligated to consider all the evidence, and you all have been schooled on, and I probably should wait till we get into deliberation about that. But concerning your question about nearby well-related, just keep focused on the overarching legal issue, which relates to the character of the district. The guidelines are guidelines, and all of the evidence that has been presented, and contra evidence which may not have been presented. That is all to be considered as you wrestle with the fundamental issue of, is it congruous with the special character of district overall? Lot of words, I apologize.
No, but I understand.
But we don't know what surrounding is, and the application of just the surrounding properties is somewhat limited. You need to be looking at that special character in the entire district, not just concentrating on three examples as relates to an increase in mass.
Okay.
Staff, any additional comments on that? I'll provide the applicant an opportunity to respond to that discussion if you feel necessary.
No, I appreciate, I mean, we're on the same page about that, and it's, I actually did the search for the well-related nearby, because we talk about it at DRAC all the time, and it's actually not in there. It's the surrounding. And so I just offered that up because this has been an issue for a long time. How do you define that? And it's time for that another time. I would like to just say one last thing, and that is that if you chose to deny this application, I would encourage you to find the facts that you would deny it. And I have not been able to find the facts to base a denial on.
Curtis, any additional questions?
No.
Jordan? No. John, do you have any questions? No, not yet. Rob, any additional questions?
Nope.
At this time, I will close the evidentiary hearing and proceed to committee discussion.
I've got a question for Raz, because I made the statement that I disagreed with the way the language read about open space, and I don't want to continue disputing that. I don't agree with what Mr. Maurer said, but I could be wrong. So I'm just going to read what that section says. And Raz, I'd like an interpretation on that. Certainly. So I believe he's referring to 3.211. So it's not appropriate to construct an addition that significantly changes the proportion of the original built mass to open space on the individual site. And not just in this case, but I've always read that as the very end of that, the individual site being the principal site as it is now. And I feel like, if I'm wrong on that, then it changes the way built mass might be interpreted. And I guess really need to understand, probably for this case and future, how built mass should be calculated. And you're smiling because it's come up every time I've been here, because I like to understand math for how these things are calculated.
That it's not defined. There may be some precedent that has evolved on how that's to be interpreted. I'm not aware. Staff may comment on that. My understanding is that the applicant is suggesting that the determination of the ratio of the original, or the increase rather, in the original ratio of building to site, that to the ratio of building to site that is embodied in the application, the term original references a period in time beginning at the beginning of the period of significance. And I think the amount of mass on this lot was different. If you go back before 1935, sure, I think is the date. And in addition, there was a subdivision. So right, the relationship is different as to size, and it's different as to what is the site that is comprising the lot that accommodated this structure. So do you begin that examination at the period of significance and what might have been original as to size or shape or configuration of lot, whether that goes back before that point in time? And it is not defined.
Okay.
And you have to look at the intent of the guidelines and the intent of this process.
Sure.
To help you with that, but
okay,
I don't have any better advice than that to you.
Got it. Well, I can see the argument that's being made by the way it was calculated. Okay.
And staff may have some thoughts about that.
Okay.
That's framework.
Staff, do you have any comments?
Nothing additional.
Okay. Wes, are we in the deliberation portion?
You're in discussion and deliberation, okay,
yeah. I just wanted to say to commissioners, so 3.2.7, limit the size and the scale of an addition in relationship to the historic building so that it does not diminish or visually overpower the building. That's the one I'm having a hard time with, because the new two-story wall is in fact longer than the principal structure.
I have another question. Last time when we were discussing this,
You might want to use the mic.
last time when we were discussing this, there was a lot of debate and discussion about how far the upper story on the back projected towards the lot line. Our issue at that time was to, I think, resolve two issues. One being 3.2.7, and also to provide more volume, I guess, because there's not it wouldn't be necessarily creating more open space on the ground plane, but to create more volume of open space by pushing the addition on the second floor back so that it was not on the same plane as the lower level. We were looking at that, and I know that the applicant is probably sitting here saying, well, the dormer on that existing second floor is in line with the first floor, but the dormer is a short piece that doesn't extend above the existing roof of that old garage. This element extends a full story above that garage. And so the concern comes in, and I need to find the exact guideline in here that speaks to that. Do you have it on your head? To the open space issue. You're just so good at this, Rob. I'm putting you on the spot.
I think that's back to 3.211.
Okay. Yeah, exactly. Original built mass space to open space on the individual site. And so because it is basically on as close to the property line as you can possibly get, the house next door comes into play in terms of the open space between the two. And I agree with Rob in terms of understanding this relative to open space between elements, not necessarily just the numbers of the volume. That's my 2 cents.
Curtis, any comments?
Yeah. I was going over the precedent images that are in evidence here, and staff comments show that 5 of the 8 images were not COA, did not receive a COA. They were prior to the designation. So there are 3 images really that are perhaps we can look to for precedent as to what our commission has done. 406 Kinsey, 726 South Boylan, and 402 Cutler. Probably, in my opinion, the one that is probably most applicable because it is on an alley at its side is the 726 South Boylan. And what we're lacking is something that's telling us, that's doing comparison between what's proposed and what's happening. That said, looking at the photographs, the addition does seem to be similarly as massive, and lacking any evidence to the contrary. My inclination is to approve this addition based on its congruity with the rest of the neighborhood, given the evidence we have received. And I'm not sure where to go with that or what to do with it, frankly. The 2 other that had COAs are similarly massive, it seems, from the photographic evidence. lacking any numerical evidence.
When you say similarly massed, what do you mean?
This the size of the addition, massive, overall scale.
Similar to this one?
Yeah. That's more of an opinion than a fact, because then we'll get photographs trying to interpolate, right? So those are my 2 bits.
Jordan.
Rob, it sounds like your 2 largest hangups are 3.27 and 3.211. And I wonder if, well, it seems like, and Raz, feel free to chime in here, 11 seems to be unresolvable, maybe, just based on a lot of things. We're not going to get to the bottom of that tonight, or maybe ever.
Guideline point 11 relates to the increase from the original to what is being proposed. Point 2.12 is just simply looking at the application and looking at overall the massing that is being proposed. It's subtle, but one relates just to the change that is being suggested versus the end product that is being suggested, looked at in isolation.
And I believe in the past, we've interpreted the word mass to really mean footprint. And so it's kind of a bad term, frankly, in the guidelines.
Well, but mass is mass, not footprint.
Well, my English definition is, yeah. What can I say?
Yeah, I think probably we're hard pressed to. I think we're hard pressed to have any other conclusion except that it means volume,
Right.
not just the footprint.
Right.
So I wonder if we leave 11 aside, if 7 is as much about where it's located in the neighborhood and how visible it is compared to some of these other precedent images that maybe don't back up to such a visible street but have similar massing at the edges of their site. So, considering all of the other guidelines that seem to be adhered to, I'm sort of inclined to let this one go. What do you think about that? What say
You're welcome to make a motion.
Before
it's motion
that,
time yet.
Rob, it does seem that just based on your discussion that you would be leaning towards finding that the proposed addition is incongruous with the special character of the district. And I just wanted you to comment on what you see as the evidence and facts that that has been competent evidence and facts that have been presented in the hearing that would support that conclusion. Mm-hmm. And I'm going to ask the same question to Curtis, so don't feel like I'm.
No, it's fine.
I
realize I'm talking to several attorneys, so. So, 3.2.7. I will admit it is somewhat subjective because it's asking, limit the size so that it is not diminishing or visually overpowering. That's not a measurable. There's not a metric that we can use for that. But, the special character of the neighborhood is, speaks a lot to generally deeper rear lot lines and, access to things like garages and services from the alleys, which is one of the character defining features of this district. Mm-hmm. This site had that at one time prior to being subdivided. So I feel like we're going away from what the special character of the neighborhood was.
Well, and that alleyway provided a dimension of open space that was set in stone while it was still there. And since it is gone, that characterization, that district characterization in my opinion, doesn't go away. It's just that the alley is gone, and therefore the space has to be kept in more fundamental ways.
That's right. And I will, and this is not just on the fly, because I had highlighted sections of the, of the guidelines before we came here. Guidelines, special character of Boylan Heights does say, recent years have seen the construction of increasing numbers of rear yard wooden privacy fences, segmented lots, and reducing the flow of space behind houses. So that would support, the evolution of the change of the character, which, that said, given the lot size that's remaining, I feel like it's not congruous with the spirit of 3.2.7.
And how do you respond to 3.2.11, or do you? Okay.
I don't.
Gotcha.
And Curtis, same question, but phrased a little bit differently. Just based on discussion, it sounds like you're leaning towards finding that the proposed change is congruous with the special character of the district. And I would want to hear from you as to what evidence and facts you believe have been presented to support that conclusion.
Primarily the photographic evidence that I spoke of earlier, the reality that we're dealing with a corner lot, and corner lots tend to be atypical in this district as well as others. And this also, we're dealing with the reality that this lot was subdivided in a fashion that is not congruous with the district to begin with.
Right.
Which doesn't, the current case before us shouldn't pay for that bad decision whenever that happened. I assume it was before the district, right? So, I mean, based on that, based on the visual evidence on those three properties, that's what allows me to bend towards approval. And given that we're told that we must approve unless there is a reason not to, paraphrasing what I understand the law to be, and correct me if I'm wrong, that's why I'm leaning off in that direction.
Let me just add to that, because you all, of course, have had sessions, training sessions, given the state of the law now. And in a quasi-judicial proceeding, the applicant has the burden of not persuading, not selling you on the evidence, but of producing sufficient, competent evidence, which tends to show that overall the proposal is congruous in light of these guidelines.
Right.
Now, the guidelines are 110 pages long, so you're looking at the details of the guidelines, but no one guideline is necessarily pivotal. You have to keep that main legal issue in focus, which is just the congruity with the character of the district. If there is no opposition evidence, so long as the applicant has produced, not proven, but produced substantial competent evidence that tends to make the case. If there's no opposition evidence, if there's no contra evidence on that point, you're obligated to accept it as believable and to a limited degree compelling, unless you find that it's just not competent, substantial material evidence that is on point that meets that burden. And frankly, it's a rather low bar under the law, as you all have been convinced. And I hope I haven't, colored your decision too much, but I think it's fair to say that is the law that you all are subject to.
Well, something you just said that informs my thoughts too is re-highlighting the word congruity as opposed to equality, right? It has to, on mass, on overall weighing, work with the special character of the district. Doesn't have to be 100%. And again, I find this case in particular to be very atypical because of those two facts that make it non-precedent setting in my mind, the corner lot and the atypical subdivision. And those are not facts that were presented here, frankly, but it is a reality. I think those help speak to its approval.
Hold on just a second. It appeared that the applicant wanted to provide additional information. You'd stepped up. I didn't know if you wanted to say anything.
Yeah, just very briefly.
If so, I'll reopen the evidentiary hearing.
Thank you. The alley is still there. The house is on the other side. The little house is on the other side of the alley. It's still there. So we never lost the alley.
Okay.
Secondly, page 43 of the application actually cites 9 projects of this mass and scale. So I know we just submitted 3 new ones last time, and there's been reference of the 3. There's actually 9 cited on that within the neighborhood that addresses these guidelines. So I just want to make that clear. It's not just 3. There are 9 examples in the neighborhood that deal with corner lots, massive additions, just size of house, all of those things. Are we going to find this exact project in Boylan Heights? No. But to the point, the discussion that's being made, there's enough of the guidelines that we are meeting based on all this other evidentiary.
Yeah, I would beg the question, though, in terms of the 9 that you've mentioned, how many of those are produced through this COA process versus having not gone through it at all?
3.
Except for that one.
Some of those are masses that were built within the period of significance, which in my mind counts just as equally.
Okay.
Right.
Okay.
And David, you said we didn't lose the alley, but could you clarify on that statement that this house does not have access to the alley, right? It does?
No, that is correct. The
Okay.
house, because the lot was subdivided, the back 50 feet or whatever it was, was subdivided off. So this, because it has access to 2 streets, it didn't need the alley.
Sure. Yeah.
Right.
Yeah. And just to clarify, when I was meaning access from this house currently to the alley, like that's been eroded because of the subdivision. Not that the alley went away, but we're on the same page.
Right. Which is to Mr. Casefang's point.
Okay.
It's an anomaly in the neighborhood.
That's right.
Are there any questions from the commissioners based on this additional information?
No.
No.
All right, we'll re-enter the discussion portion of this case.
Curtis, not to beg the question, but just plain devil's advocate, if it is the situation of a corner lot, it makes it an anomaly. Most corner lots that we deal with are considered 2 front faces.
Right. Yes.
So why would I not argue that it's even more important, given the massing of the addition to the original?
Honestly, I could argue it both ways myself. The fact that it was a subdivided corner lot, and I think an appropriately subdivided corner lot, I think just makes it a weirder situation overall too, a harder situation overall. The 711 McCullough Street, which was one of the photographic evidence ones on page 41 of 47, does show a very massive structure facing McCullough Street that I think, if just sort of reading it visually, exceeds the size of the addition in question, property in question overall. But again, this was prior to designation, and it appears to be multiple additions that happened in that window, but what window, I don't know.
So Curtis, a few things on that particular house is it is a very nicely done addition. Sure, that's editorial. There's a lot of open space beyond it to the alley, like over 30 feet. And the space from that addition to the street, McCulloch Street, is also substantial. So it feels somewhat different to me. And it also has been, I mean, I don't know at what point it was constructed, but even on IMAPs, it's prior to the oldest satellite photo, 1981.
Yeah.
So, that's sort of like David Mauer's point of, it being from a time prior to maybe even incorporation as a district potentially maybe makes it part,
Grandfathered in.
yeah, in a way.
Yeah.
Curtis, any additional comments?
No, other than given how much we've discussed this, I think that if there ever was a case that hopefully has a divided vote, this is one that needs that. Just to, again, from precedent point of view, it was not unanimously approved. An opinion.
Jordan, any comments? No. John?
No.
Rob?
Nope.
All right, I'm going to move that the application be approved, subject to the following conditions. One, that the fiber cement or composite trim be painted and installed with the smooth side facing out. Two, that the following be provided to and accepted by staff prior to installation or construction. A, manufacturer's samples for paint, if changing. B, HVAC location and screening, if changing. C, drawing showing installation locations for gutters and downspouts. D, exterior lighting specifications and location, if any. Is there a second?
I'll second.
Motion having been made and seconded by Curtis Casefang, I will call the roll and indicate whether you vote yes or no. Curtis?
Aye.
Jordan?
Aye.
John?
No.
Rob?
No.
I vote yes. So the motion has been approved, 3-2. Thank you for your time. It has been a long process, and I hope you appreciate I know we appreciate the work you all put into it. I hope you can appreciate even though it may have been frustrating and maybe a little anger-inducing, the time that the commission has spent weighing this project over several months now. Again, the motion has been approved 3-2, subject to the conditions as laid out in the staff report. The final vote of approval will be conducted next month when the meeting minutes are approved, and you will be informed of that. Thank you.
Thank you so much. One thing to note, the gutters and downspouts are provided on those drawings.
I also wanted to say thanks, and I will say the deliberation is healthy and welcome, and I think the project got better because of it. So thank you.
Thank you.
Thank you.
All right, next is new application COA 0093-2022, 407 South Boylan Avenue. I ask that the applicants and anyone presenting on that matter please come forward, state your name and address for the record.
Jennifer Simpson, 407 South Boylan.
And Dean Bros, attorney, 1414 Raleigh Road, Chapel Hill.
And I'll note that the property owner is here. Will you both be presenting on the application today?
Primarily Ms. Simpson.
Okay. Well, just in case both of you, if you mind, I'll go ahead and swear both of you in. Do you solemnly swear or affirm the testimony you are about to provide at this hearing for the matter on today's agenda is the truth, the whole truth, and nothing but the truth? I do. Thank you. At this time, I'll recognize staff for their presentation.
All right, this application is for 407 South Boylan Avenue in the Boylan Heights Historic District. The request is to construct a 6-foot side fence, construct a 4-foot tall, 8-foot wide double gate, and remove some shrub overgrowth. Next slide. I can handle that. This is a view of the current house as it exists from Boylan Avenue. and a view of the existing driveway looking down the side property line where the fence is proposed to be installed. A closer view of that area. Some existing trees and fence at the property proposed to be removed. Not the trees, but as a part of the new fence. And the rear property line as well. Staff concerns, it's unclear if the 6-foot fence will be constructed forward of the front wall of the subject property house and therefore located within the front yard.
All right, at this time I'll recognize the applicant for their presentation.
Sure. I brought along 10 copies just of a revised site plan to address staff concerns, just to be clear about, I know that the pictures may not be clear, but this is intended to be clear about how far forward the fence will come. If you look at the drawing, the green is my next door neighbor's home, and the green that's parallel to South Boylan Avenue is their white gate that's along their driveway, which is parallel to their front wall. My front wall of 407 South Boylan is further forward than that. It's about 5 feet forward. So the new fence will start at the neighbor's gate, which is that green line. It's about 5 feet back from my front. And other than that, just to be clear, we're not taking any trees out. You can see that we've designed the fence to either stop and start for that first tree or work around it.
Is that all?
That's all.
Okay. Is there anyone present who wishes to speak in support of the application? Is there anyone present who wishes to speak in opposition to the case? Anyone present with questions or comments on the application? All right, we'll move forward with questions from commissioners. Curtis, do you have any?
Not at this time.
Jordan?
No.
John?
I couldn't tell from the photograph necessarily. Do you know what the height of the gate is, the drive for the neighbor?
Yes, it's about 4 feet. So my gate will also be 4 feet. The driveway gate, just the fence will be 6 feet.
Okay.
Any additional questions, John?
No.
Rob?
So on the new evidence on the site plan.
Yeah.
So the entirety of I'm going to call it the blue line is the 6-foot high fence, or does it step down where you have your gate?
It does not step down.
Okay.
Yeah.
That's my only question.
Any additional questions from the commissioners? Hearing none, we'll close the evidentiary portion of the hearing and move to committee discussion. Curtis, any comments?
Not at this time, no.
Jordan?
No.
John?
Just, this would resolve itself really nicely for me if the gates were 42 inches high, not 4 feet, and not 4 feet. And that, I know that, because correct me on this if I'm wrong, staff, they can have a 6-foot fence on the side yard, but because it's from the back front face of the house. Is that correct?
So we regularly approve, staff can only approve 42 inches in height for a fence, which is why this case is before you tonight. It's taller than that. But let me scroll to the staff concern tab. So our main question was if it aligned with the neighbor's gate as proposed, would it be forward of the front wall of the house of the subject property? And that is where we define the front yard as beginning.
Okay.
So if it's behind that, it's considered side or rear yard.
Okay. Okay. And clearly from this is 5 foot back from the front face of the house.
Correct.
Yeah. I would, I think because of what where I come in is the front face of what you see from the street. I'm going off of basically what we have in Glenwood, Brooklyn, which is historical light, but what you can see from the street is what matters. And idyllically, it would be nice if those two gates were at 42 inches, which is what I think the existing gates are for that neighborhood, for the neighbor's driveway, to tell you the truth. I would be okay with keeping the 6-foot fence between the properties.
All the way forward.
Yeah.
And just to clarify, in Glenwood, Brooklyn, it's between the front wall of the house and the street that site features are regulated. So it would apply similarly in this
Okay.
state. Just because it's visible from the street doesn't mean it's regulated.
I mean, I go back and forth between 42 inches from the back face of the house all the way to the street, and so that one section of the backyard is at 6 feet, but then the rest is at 42. But that's design shit, design stuff.
Is that in the minutes?
Yeah, please take that out.
Rob, any comments?
Yeah, I just, because we just spoke about the special character of the neighborhood in the last case, part of the Boylan Heights special character statement says, recent years have seen construction of increasing number of rear yard wooden privacy fences, segmented lots, and reducing the flow of space between houses. I'm just having a hard time with the 6-foot fence coming all the way to the front of the neighbor's house. I realize it's set back from the principal structure, but it's separating properties, so it's becoming more dominant. I would really love to see the portion that's along the driveway be a 42-inch high fence also. I feel like that would be more congruous with the character of the neighborhood.
Yeah.
I have no other statements though.
I was going the same direction. I just didn't know what guideline I could put to that.
John, if you haven't learned, Raz always says, look at the special character of the neighborhood.
Okay.
They are good.
In looking at the special character of the neighborhood.
They are important.
Yeah, I think that it does question 42 inches versus 6 feet when it's a very prominent section of that fence. I don't have a problem with it being in the backyard because I get that.
Agreed.
But having the gate that is existing in the neighbor's driveway, which I have a tendency, like I said before, to believe it's probably 42 or an average of 42, given the fact that it's got an arch to it. If your gate in the back and that fence that is a section between the two gates came to 42, I would be thrilled. I say that with somewhat editorializing because I don't know what guideline I would pick to point to that says you can't do it. That's all. Other than the special character of the neighborhood.
If it's helpful, I'm just looking through the guidelines here to that relate to fences and walls, section 1.4. The relevant guideline would be 1.4.11, which states it is not appropriate to introduce visually opaque screening plantings, walls, or fences taller than 42 inches or that are more than 65% solid into the front yard area and or street side yard area of a corner lot unless historic evidence exists.
There we have it.
Well, it doesn't address this is not a corner lot, so my reading of that is the side yard would not apply in this case because it's a mid-block and not a, is it?
You may also consider 1.4.8, introduce compatible new fences and walls constructed of traditional materials only in locations and configurations that are characteristic of the historic district.
Thank you.
Well, then I could point to that. I
Could we agree on condition?
Yeah, that's
Those
what I was
conditions?
wondering.
I mean,
We
I
could do it
think
as a
that's,
condition.
You may want to ask the applicant if they are.
thank you.
What is it exactly that you want to?
Well, and before you ask that question, Raz, is that something that we aren't supposed to do?
Well, you know, the committee's focus is on the evidence that you have heard. It's a good idea to just ask yourselves, what evidence have we heard to show that this proposal is congruous or not incongruous with the special character of the district? In theory, at least, if there is no guideline that directly addresses the proposal, your hands are not tied, because you simply make your decision in light of the guidelines, but the overarching issue is special character and what evidence you have heard or what evidence you haven't heard to show that it's congruous or incongruous. If they have met their burden of producing a prima facie case, that is, showing some substantial evidence of congruity, then you're required to issue the permit or to approve the application. If they haven't, you could make a finding that they have not produced substantial competent material evidence to show congruity with the special character of the district. So that is the framework. The guidelines, as I said before, are guidelines, and I thought the guidelines cover just about every scenario that you can imagine, but there are situations where the guidelines don't really give you clear focus or direction, and this may be one of those cases.
Well, I think Curtis was going to say something.
I think if we can hang our hat on the 1.4.8 as far as the character of the district and the lack of evidence showing congruity or not of that situation, just to ask that it be brought down to 42 inches and make that a condition and call it done.
I mean, we could, I think what we could do is ask the applicant, which direction would you like to go? Would you like to do research in the neighborhood to find evidentiary facts that support doing what the design that you have right now? Or two, would you be amenable to having a condition put on your approval today that would require that we keep it at 42 inches in the front face?
I believe the applicant, go ahead.
Well, my next door neighbor and I have a good relationship. He is not here because his wife has dementia. They put their trash cans near the front of the house, which is the purpose of the 6-foot fence that I see his side yard from my office at the house. And so if you're telling me you'd need more evidence, I would rather have the time to go collect that evidence. If there truly is no need for that, I'd prefer to just keep it as submitted and have you approve it. So you can let me know which one.
We could defer it.
Any questions from the commissioners based on this information?
No.
Thank you.
Before you close the public hearing, I would just like to reiterate, I'm not sure if I was clear when reading guideline 4.2.11, it refers specifically to fences taller than 42 inches located within the front yard, which is why staff's concern was about whether or not this fence would be forward of the front wall of the house where the front yard is defined as beginning. So I believe the applicant has now stated and provided a revised site plan that the fence will be 5 feet back from the front wall of the house, putting it out of the front yard and into the side yard.
Okay.
It doesn't appear that the fence is going beyond the front yard wall or the front wall of the house. So if it doesn't do that, then it can be taller than 42 inches. Is that correct?
According to 4.2.11, yes.
And the proposed height is
1.4.
obviously taller than 42 inches because that's why the application's here.
Yeah.
Okay.
And where is front yard defined?
If it is forward of the front wall of the house,
Yeah, but
it
where is that defined?
that
Where-
is the wall. Oh, well, I suppose that is the precedent definition. And that is not the front of the porch, where the structure begins, but the wall where the windows and doors and siding are located, the actual enclosed wall.
Gotcha.
And that's the same rule of construction for zoning setbacks. I mean, the front beginning of the front yard, that is a generally recognized benchmark.
Okay.
My fellow commission members can help me see what concerns they have because either I'm not seeing it or I'm not understanding it clearly.
In 4.8, 1.4.8, we're referring to the height of new fences and walls that are consistent with the traditional fences and walls in the district or landmark. This 6-foot fence is out of character with that understanding. That being said, 1.4.11 basically clearly states and puts this into a side yard condition. So it is a discussion between two different takes on two different guidelines.
If I could ask, does anyone know what the traditional height of fences within the district are?
Well, my suspicion is it varies, but I think, Jordan, where I'm hung up when I mentioned the special characters, I can't think of other locations where there's a 6-foot fence that comes this far forward. Typically, they're engaged at the back, and the precedents that are in the application are shown that way too, which I feel like if there's a typical, it's tying into a rear corner condition.
I'll reiterate that Rob is correct. Fence heights in the district do vary a great deal. If there are any historic fences remaining to be referenced, they're likely post and wire, which that just depends on how tall your posts are and how much wire you strung between them, which they're largely very, visually transparent compared to a typical wooden privacy fence. But as stated in the special character essay for this district and frankly existing in many neighborhoods in Raleigh, other historic districts as well, wooden privacy fences are not in a typical condition. Though most, if not all, are likely not historic.
Based on what the applicant has said, I like the idea of allowing them time to provide additional, seems like
Facts.
committed to doing this, so additional fact-finding would be fine with me.
Yeah, I agree. I think to defer it would be ideal. I so move. Can we do that now?
May I ask a question before you go there?
Sure.
So I brought Mr. Brose because it was required that I bring an attorney. Will I need to bring him again next time?
Unfortunately, yes, for the quasi-judicial hearing, trusts are required to be represented
trusts.
by attorneys.
What's a trust?
Raz, if that is not the correct interpretation, which I believe we have received from the city attorney's office some guidance on that, please do weigh in.
Claire, I don't know the particulars about this application and who applied and the owner of the property and so on and so forth. The applicant property owner is entitled to present evidence supporting his or her case. But when we have a business entity, an LLC or a corporate entity or partnership that is the owner of the property, then the applicant has to be the owner. And there's a problem with unauthorized practice for someone to appear in a representative capacity and make arguments and do the sorts of things an attorney would do to make a case. I don't know if,
So I am the owner and I am the trustee of my own trust in my name. It's just family planning purposes. Yeah.
and this, there have been state bar ethics opinions on this, and I'm not sure if this was the circumstance that led to the city attorney's office weighing in on whether a trustee situation required a lawyer. It seems I recall there being some conversation about that, and I think they did say it was, they had conferred with the state bar, and the state bar gave an opinion that if it was a trustee ownership situation, the trustee could not appear, summarize case, present evidence, and make presentation because that would run afoul of the unauthorized practice principles. I think that's what's going on here, so probably that's what's the driver.
Yes, the owner.
Mr. Ross is here this evening. So I think the answer is yes.
Yes.
Probably would be a good idea to have your attorney present.
And when is the next meeting, just before I?
December 8th.
Yeah.
And for what it's worth, you will be the first one on the agenda since you'll be the first case in old applications.
Do I need to make a decision right this moment, or can I do it before the end of the meeting on which way I want to go? Whether I just change it to 42 inches and you approve it?
If you want to,
What we are able to do for you today is give you a deferral until next month, or we need to decide today which direction and what conditions, if any, we add to that application.
Okay, and so just to be clear, if I say, fine, we'll do 42 inches, could it be potentially approved this evening, or do I still need to come back in December with a new site plan?
Yeah.
Okay,
No, it would.
It would be approved
it would
with
be
those
approved
conditions.
With those
Okay.
conditions.
okay, well, let's do the 42 inches then. I'm not able to come in December, so.
Okay.
I can do a motion.
Please.
Okay.
Yeah.
I move that based on the application, the evidence presented during the public hearing, that we approve the application with the following conditions. One, that the tree protection plan be implemented and remain in place for the duration of construction. Two, that the following materials and specifications be submitted to and approved by staff prior to issuance of the blue card. A revised site plan clearly showing that the fences proposed will not, actually, we don't need that. We have that. Let's take that out. Okay, that's one. Number two, that the new gate and fence street side of the new gate be no taller than 42 inches and no more than 65% solid. So that's it.
motion has been made. Is there a second?
Second.
All in favor say aye.
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 Any opposed? All right, the motion carries unanimously. Thank you for the time and effort spent on the application. The official decision will be made at next month's meeting when the minutes are approved, and you'll be informed at that time. Thank you. All right, next is COA 0105-2022, which is 2212 Bedford Avenue. I'll ask that the applicant and anyone presenting on that case please come forward to the podium.
Oh my gosh.
Ask that you please introduce yourself, state your name and address for the record, please.
Good evening, Mr. Chair. Chad Essick with Porter Sproul, 301 Fayetteville Street, Suite 1900.
Dennis Fitzgerald with DJF Builders, 3717 National Drive, Raleigh.
And is the property owner present? Great, thank you. All right, at this time, I'm sorry, will you both be presenting on the application today, or just you, Mr. Essick?
Probably just me, but probably
Yeah, we'll go ahead and swear both of you in. Can you please raise your right hand? Do you each solemnly swear or affirm that the testimony you're about to give on the matters is the truth, the whole truth, and nothing but the truth? Thank you. This time I'll recognize staff for their presentation.
All right, as you mentioned, this is KCOA 0105-2022 for 2212 Bedford Avenue. It is in the Oberlin Village Historic District, and the nature of the request is to demolish the house and front porch steps, remove accessory structure, remove driveway and front walk, remove 5 trees, remove landscaping and site features, including pond, fence, and rear patio. And you can see the location of the property here on the map. This is a view of the house from Bedford Avenue. And a view at the end of the driveway, the front porch. This is the east yard. From here, there are many photos. If you went on your site visit, you'll know that the backyard is a little bit of a jungle. It's a little difficult to view some of the existing structure. This is the east facade. This is the rear portion of the east facade looking back towards the screen porch. And this is the fence and wall that are proposed to be removed. Again, that fence. On the other side of the fence, there is an accessory structure that is also proposed to be removed. And here you can see that accessory structure to the right, the existing screen porch, and portions of the rear facade and screen porch again. This is the west yard. It's a little bit difficult to see the site features here, but there is like a pond structure in there. And looking back towards the front of that accessory structure, some of the staff concerns, as noted in the staff report, were that there was no evidence provided that asserted that the structure had no significance or value towards maintaining the character of the district. There was no evidence provided identifying structural deficiencies, if any. It was a little unclear which trees, if any, were to be removed. And then the remainder of the demolition design guidelines that ask about salvage, documentation of the structure before demolition, and future development details were not provided. The applicant does have a presentation that I have attached here. And Chad, you can go through this. You can either use the keyboard arrows over there, or I can scroll through for you.
I've used it before.
Okay, perfect.
Ready for me? Yes. Okay.
Sorry, I just assumed that you would take Colette's lead to proceed. My apologies.
So good evening, Mr. Chair, members of the committee. Again, my name is Chad Essick. I'm a land use and zoning attorney with the law firm of Porter Sproul here in Raleigh. I'm here tonight on behalf of DJF Builders in connection with this COA application for demolition of certain site features at 2212 Bedford Avenue within the Oberlin Village Historic Overlay District. Joining me here tonight is President of DJF Builders, Dennis Fitzgerald. DJF is a home builder that's based here in Raleigh. He's been building single-family homes for more than 20 years in the Raleigh market. DJF acquired this property in June of this past year, which I'll discuss in more detail in a moment, is in significant disrepair, and has not been habitable for some time. As staff noted, this is a 0.14 acre lot. Currently located on this lot is a brick ranch that was constructed in or around 1960, which is towards the end of the period of significance for the Oberlin Village Historic District, which runs through 1970, as noted in the historic research report for the Oberlin Village District. The This house was built, as I said, in and around 1960 by Mary Jones, who relocated to this site as a result of the construction of Wade Avenue. She lived there until her death, and then her heirs owned the property, and I believe, is my understanding, her grandson lived there for some period of time. It was sold in April of 2022, and then again sold to DJF Builders in June of 2022. As I'll discuss in more detail in a moment, virtually all of the major components of the home need to be replaced. There are certain structural deficiencies within the home. It contains asbestos and mold, and as noted, has not been habitable for some time. I've included in your packet a number of aerials of the property over the last 30 or so years based on what's available on IMAPs. That's under tab 3 of the materials I provided. Based on the IMAP's aerial photography, it appears that the accessory shed in the rear of the property, as well as the screen patio, was added to this home sometime between 1988 and 1999. If you look at there's a gap in the aerial photography on IMAPs, but it appears during that period of time. It appears also from those aerials that the patio was covered and it was screened sometime after that. Also not clear, but it appears there was aluminum siding that was added to the front facade and the overhangs of the home at some point. Similarly, based on aerial photography, there was a fish pond that was added in the rear of the property sometime between 2005 and 2007. That, as staff went through, that fish pond really no longer exists. It's inoperable, and there's significant vegetative growth that covers it. I was going to run through the pictures in my packet on my PowerPoint presentation, although staff has done a fairly good job of going through those pictures, so maybe out of respect for the commission's time, I won't run through all the pictures I have, but they are in your packet, and I'm certainly happy to answer any questions. As I noted, we did have a home inspection report completed, and I've included that report in your materials under tab 4. I don't want to go through the whole thing, but I thought I might highlight a few things from the report for the committee's benefit. In that report, a number of things have been designated as needing to be replaced. The roof coverings, roof flashing, roof drainage systems, wall cladding, fashing and trim, exterior doors, porches, decks, stoops, balconies, the soffit, the eaves, the driveways, the walkways, structural components such as the crawl space, floor slab, piers, columns, foundation walls, floor joists, subflooring, roof framing, the plumbing drain, waste and vent systems, plumbing water supply, distribution systems and fixtures. There's a number of references in the report to large cracks and displaced sections of the driveway, cracking in the rear left corner of the foundation walls, and sections of the foundation wall have settled. Subflooring is water stained and damaged in several areas inside the crawl space. The added support structures in the crawl space do not meet current construction standards. There is fungus and mildew, and wood deterioration is present in some of the wood frame components of the flooring system. The front right roof has a large dip. There are cracks as well as deteriorated areas at the edge of the cement crown and around the perimeter on top of the front chimney. Obviously, the home, with homes built in this time, do not have central AC. There's fungal growth on the left rear bedroom walls. Again, that's interior, but I note that. There's stair step or shear cracks in brick veneer at the exterior of the house, and the crawl space foundation wall, opening retaining wall has failed. So those are just some of the things coming out of that home inspection report that we wanted to highlight for you and make aware for the committee. So based on this, it's our opinion that the demolition is the most appropriate option for this home at this point, and it's how DJF plans to proceed. I'll note that we have spoken with 3 of the neighbors, one to the west, Peter and Jesse Mack. I don't know if they're, are you guys here? Oh. I spoke with Jesse in advance of tonight's hearing. Also spoke with the property owner to the north, Chad Griffith. I don't know if Chad's here. I've also spoken with the property owner across Bedford Avenue at the corner of Bedford and Oberlin. In my conversations with them, they had questions, clarifying questions regarding fencing, which I'll get into in a minute, and what's being removed and what's not, and as well as trees, which I'll talk about here in just a minute. But all of those folks that I spoke with supported the removal of this home and demolition of this home as soon as possible, given its current state and current condition. I don't want to speak for them. They may say may have a different view, but that was my conversation with them when I spoke with them. Since our original submittal, we have revised our plan for demolition in order to clarify a few things in my conversations with the neighbors, as well as in response to some of staff's comments that came out of the staff report. We had originally noted in our application the removal of fencing, which I think caused some confusion, and that's my fault. To be clear, the wood fencing that surrounds the site to the west, the north, and the east, that's fencing that's located on those adjoining property owners' lots. So we're clearly not going to remove that fencing as a part of our demolition, and we've clarified that on our revised plan that's before you under tab 1 of the materials. The only fencing that's to be removed, there's a chain link fence that runs along a portion of the eastern boundary line. I have a picture of that if you'd like to see it in my materials. Right there. That chain link fence there. And then we'd also be removing this fencing that's interior to the site, this white fencing. So we've clarified that on our plan that we've provided. There was also questions regarding trees and what trees were going to be removed. And so we have clarified on our plan here. There are 5 trees that were identified as being large under the guidelines, greater than 8 inches in diameter. So we've identified those here. We intend, we don't want to remove. It's an additional cost to us. We don't want to remove trees if we don't have to. So 4 of those 5 trees we've indicated along the perimeter that we do not plan to remove, and we will be providing tree protection around those trees in order to help prevent damage to those critical root zones. The only tree that will be removed is the is the myrtle tree that's right behind the shed there, where we've noted to be removed. Just to clarify staff's comments as well as questions from the neighbors, we've clarified that on our plan as far as what trees would remain and would be removed. Obviously, a number of those trees have ivy growing up in them that needs to be probably pruned and evaluated for their healthiness, but we have no plans to remove those as a part of those trees we've identified as a part of the demolition. So looking at the demolition guidelines under 4.2, again, we do not see alternatives to demolition for this particular site. We've under item 2, before demolition, record significant features through photographs. We've provided a number of photographs of the home in order to record the structure. We're happy to provide more picture and more photographs if the committee would like. There's a lot of overgrown landscaping, especially on the west elevation, which is close to the property line. So once that's removed, we could provide more documentation if that's desired. Before demolition, identify salvageable, usable architectural materials and features. In our review of the home, we've not identified any architectural materials or features that are salvageable. However, in viewing these photographs that you've seen, or during your site visit, if you went to the site, if you've identified any architectural materials that should be salvaged or for potential donation, we're happy to consider it if you would let us know. Before demolition, submit a plan to the commission illustrating proposed site development or plantings to follow demolition. Again, we've submitted our plan showing the plantings that will remain and the trees that we intend to preserve. We have not gotten far enough along to identify our new plan or new proposed it will be a single family home consistent with, as we guys have been talking about, it's consistent with the character, not incongruous with the special character of the district. So we wanted to get through this process, secure the site, and then start working on new construction for a single-family home on this site, and come before the board and meet with the design committee regarding that with our architect. Ensure the safety of adjacent properties and protect trees on site from damage due to compaction of soil by equipment or materials. Again, as you'll see, we've provided protection fencing around the entire site on our plan, and we've proposed to retain 4 out of the 5 large trees on the site and provide tree protection for those trees. After demolition, clear the site promptly and thoroughly. We will clear the site immediately upon demolition, and certainly have no problem with that being a condition of approval that we do that. Again, after demolition, plant or develop the site promptly as approved in the proposed site plan. As I said, we will proceed with development as quickly as possible and plan to submit a new construction COA for a new home quickly. But we've also added a note on the plan, note 11, that if construction is not started immediately after demolition, the site should be graded flat and seed and straw placed down. So we have included that as a requirement or a note on our plan, and that would fine with that being a condition of demolition as well. Regarding the issue of whether the building has any particular significance or value towards maintaining the character of the historic overlay district, respectively, we do not believe it does. I'm not sure everyone will agree with me, but in my review of the materials for the Oberlin Village overlay, I think the historical significance is more tied to the history, the cultural, the heritage of the district. So certainly this lot within that district has that. I think that this particular home itself, it's in our opinion, does not have significance or value towards maintaining the character of the historic district, especially given the condition that the home is currently in. As I noted, the home was constructed in the early 1960s, which was toward the end of that period of historical significance. As noted in the historic research report, the district began losing its identities in the 1960s, around the same time this home was constructed on this lot. The brick ranch home is what you typically see across Raleigh for post-World War II style ranch brick homes. In our opinion, is not particularly unique or significant to this particular district. As noted, the home has had a number of site features added to it over the past 20 to 30 years, as I outlined earlier in my remarks, with the addition of the shed, the screened-in porch, and the other elements that I mentioned earlier. For these reasons, we would respectfully request that the commission approve our demolition request without delay so that we can proceed with clearing and securing the lot at the appropriate time, while also moving forward with seeking approval for a COA for new construction for a single-family home. We certainly understand it's within the purview of the commission to delay demolition for 365 days. Usually that's done to evaluate options such as relocation or options to salvage historically significant features. Respectfully, we don't believe those circumstances exist in this particular instance, and kind of imposing a delay would just delay the removal of the home, and that's not obviously our desire, but I don't think in the neighbors that I've spoken with, I don't believe that's their desire either. So with that, I want to thank you for your time and consideration. Happy to answer any questions or provide any clarification on our proposal. I would ask that the materials that's been provided to you be made part of the record. I also, again, I mentioned the neighbor across Bedford could not be here tonight. He has prepared a letter that's been notarized expressing support for our application, as well as requesting that it be approved, the demolition be approved without delay. So I have the original notarized letter, and then I have copies for the board. So provide that for the record as well. I think that's all I have. So I'm happy to answer any questions.
All right. Thank you, Mr. Essick. Are there any members of the public who wish to speak in support of the application? If you don't have to say anything if you don't want to, but if you feel led to say something, you're certainly welcome to do so. So if not, that's totally fine. All right. Are there any members of the public who wish to speak in opposition to the case? Okay. All right. Please come forward. Ask that you just introduce yourself by at the microphone. Just state your name and your address, please.
Good evening. My name is Catherine Hinton. I am representing 2208 Bedford. I am in opposition.
Hold on just a second. So just give your name and address. So now I'm going to swear you in.
Oh, okay. I'm
Just
sorry.
please raise your right hand.
Okay.
Do you solemnly swear or affirm that the testimony you are about to provide is the truth, the whole truth, and nothing but the truth?
It is.
You may proceed.
I do. Good evening. I am in opposition. I grew up in Oberlin. I went to Oberlin School, which no longer exists. The neighborhood has been constantly changed over the last, I'll say 50 years. Though, as the gentleman stated, there doesn't seem to be any significance or historical significance present. It does have significance to a few of us who grew up in the area. Mrs. Jones and other names that some people don't know still have significance to our hearts. I understand in terms of repair and the levels of repair that are needed, but I think the demolition of the building would further diminish the character of Oberlin. I just want it to be known and recorded that that area has a great significance to many of us, few of us who are still in the area. And I hope in rebuilding or just reconstruction, whatever it is, it also takes into consideration the original residents whose love for the community and then whose financial means will not continue to be able to deal with some of the prices that are put on all of the new constructions in the area. Thank you so much for your time.
Thank you. Is there anyone else who wishes to speak in opposition to the case? First, I ask that you introduce yourself by stating your name and address, please.
Well, excuse me. I'm Jessie Meck, and I live at 700 Tower Street, so I'm the neighbor to the west of the existing property. And my husband, Peter, is here. Can y'all hear me?
Yes.
Great.
All right. Before you proceed, I'm going to swear you in.
Yes.
So you please raise your right hand. Do you solemnly swear or affirm that the testimony you are about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
So I brought a statement to read, and I brought 10 copies of it, so here it is. So we're the residents of 700 Tower Street, so we're the next door neighbors on the west. First, I want to really congratulate Mr. Fitzgerald and Mr. Essick, because they did reach out and talk to us, and they have revised their plan for demolition, and we're very grateful to them for that, and we appreciate the flexibility they're showing. So our hopes are high. Nonetheless, since this is our best chance for us to stick up for what we think is important to preserve in this property, we're writing in support of all the concerns raised in the staff report as it was written. There are more than are on the slide you just showed, right? So we especially wish to highlight 2 items, and then we're going to make a comment. We feel that retention of all 7 of the large trees, which are on the northern and eastern sides on the perimeter, not just the 4 which are now marked to be preserved, would help greatly to preserve the leafy, shaded character of the neighborhood, one of its essential characteristics. So 3 of the 6 eastern boundary trees, so there are 6 large trees along the eastern side of the plot, and then there's the one that is marked on the northern side. I'm advocating for all 7 of them. Note that I'm on the western side. There's a small fruit tree and some shrubs on the west. I'm not advocating for them. They are replaceable. But the 7 trees, in my opinion, are not replaceable within a generation or 2. So 2 of those trees are very large. They're the ones that I mentioned to Mr. Essick. And you can see them from Oberlin Road. They're that tall. But it's not quite clear from the drawing submitted, the revised one, that the really tall ones are marked for being saved. If you look at that site plan, there's an interior fence marked for destruction, and that's going to be north of the 3 trees that are marked. But one of the very big trees is farther north than that one. So I would advise we keep all 7, or somebody judge what's really appropriate to be kept, as I have a problem with the plan as it's written now. Again, very grateful that preserving trees is already in the site plan. So that was point 1. And finally, just to summarize point 1, we would like to see staff concern number 3 about the trees be made into a condition of acceptance so that there's further clarification. And we would like to add that all those trees on those 2 perimeters might be candidates for saving. Okay, second point. If Mr. Fitzgerald would submit a complete development plan now, before demolition, not just a demolition plan, that would be very helpful. I am in solidarity with our neighbor on Bedford Street that what comes there next is of deep importance. So a site plan now for development plans would be very helpful. Also, in that same point, the proposed documentation of the existing structure, sketches and site plan to scale, they should be presented at this time, because we're worried that the specifics of the existing structure could become lost. So just specifically in terms of the staff report, we are advocating that suggested condition, the 3rd condition, number 3 about documentation, be a condition. And we're suggesting that concern number 7, the development plan, should be made into a condition of acceptance. So here's our further comment before we close. Peter and I really are not qualified to judge what's appropriate for destruction. Our neighbor on Bedford Street speaks for the people who are qualified to speak to that. Having said that, if it turns out that elements of the house simply can't be saved, well, we don't think that a 365 delay would be very important. If it turns out, in your opinions, that nothing is salvageable here, well, then it will have to be destroyed. Though I have to say, Mr. Essick is not quite accurate. The grandson of Mrs. Jones that he spoke of, at least I think he was her grandson, he left only a year ago. So the house has been occupied as recently as just about a year ago. Furthermore, I won't even go into that. So that's all we have to say right now. Thank you.
Thank you for your comments. I will add, just to provide some clarity based on what you did say. So for demolition COAs, this committee, we can only either approve it for it to happen now, or we can do the 365-day delay. And so after that happens, any future development will come forward to this commission again for a COA. So I just wanted to let you know.
Chair, there may also be another speaker present.
Yes.
We would place ourselves in your hands for that kind of decision.
And in the past, for staff, correct me if I'm wrong, but we have the ability, if we impose a 365-day delay, and we get through the process of working through the property, shortening that delay at a future meeting, just rescinding it. So for instance, we do a COA for new construction, in the process, we are asked to eliminate that delay. Is that true?
Yes, you have done that before.
Yeah.
If that is the way you move forward. I think in the past, you put a very specific time period with that. For example, having the applicant return in 6 months, 3 months, to revisit.
Are there any additional members of the public who wish to speak in opposition to the case? Please come forward. Ask that you introduce yourself to the committee by stating your name and address, please.
My name is Avery Costin, and I'm representing 2213 Bedford Avenue, which is the house directly across the street in front of 2212. And
before you proceed, this time I just need to swear you in. So yeah, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
I do.
You can proceed.
And I stand in solidarity with my neighbors and former neighbors. I no longer live in the area, but I have a home that is being rented out to family members. I was also on the committee, I think it's been so long ago, but to preserve the Oberlin Village. We met on a regular basis. We came up with ideas and designs for growth and development. We knew change was coming to Oberlin, but we wanted to have a part in that change. And I understand fully what development is all about. I know things cannot last forever. I have a house myself that I'm trying to make up my mind as to what I'm going to do with it. But what I'm trying to say today is that we only have part of the plan, which is demolition of the property. We ask that the builder build something that is, I would say, conducive to the existing neighborhood. Oberlin is not what it used to be. We used to know all the residents. Now you don't know all the residents, but I attended church over there and everything. But, you know, to not hold up any more of your time, like I said, I'm not standing against the builder and the new owner, but I'm asking that he take in consideration what the community means to us, the people who grew up in that area. Thank you for your time.
Thank you. Are there any additional members of the public who wish to speak in opposition to the case? Okay. Mr. Essick, would you like an opportunity just to say anything in response to what we've just heard from members of the public?
No, and I apologize if I got it wrong about how long it's been inhabitable. It was my understanding it had been a while. I didn't know exactly the amount of time. So I think there might have been some confusion. Again, we have identified all of the trees that are over 8-inch caliber on the property in our tree survey. I think trees that the property owner to the west was referring to are trees that are not on our property, that are on the property to the eastern or on another property. So we have identified all trees that are over, that meet the requirement for large trees under the guidelines, and we have committed to saving four of the 5 trees as a part of our plan and providing tree protection. You know, again, as I noted, you know, what's before you tonight is an application for a certificate of appropriateness to demolish. Again, we will have to come back. We will have these conversations about the new structure that goes there, and we'll have those conversations about its of the guidelines, as well as being not incongruous with the special character of the entire district. But we believe for this site, given the state of the home, rather than waiting a year, it's more appropriate to go ahead and clear the site and to begin the process of going through that process. That's our belief, and I think we've put forward evidence as to why we believe that to be the case and why there shouldn't be a delay. But again, that's a decision this commission can make, and we, I think in designing and spending the time and money to design a home and going through the process, you want to know when can that occur, as far as when can you be able to demolish the home. So if it's a year from now, I think the cost of materials and all sorts of things may be different than a year from now than it is today when we're designing this home. So it factors into our decision on investing in the new plans for the development as to what the commission's decision is as to when the home can be demolished. So, I'm happy to answer any other questions or clarify anything on the plan. And again, we'd ask for the approval without the delay based on the evidence that we presented here tonight.
Thank you, Mr. Essick. It was my intention to take a brief recess after this application, but I have a feeling that the remainder of this case may take a little bit of time. So if the applicant doesn't object, I'd like to enter into a brief 5-minute period of recess just to take a little break before we resume. All right, thank you.
Your pleasure, Mr. Chair.
Committee will be at ease.
It had been moved twice before that. Yeah, and it's huge.
All right, let's come back to order. At this time, I will recognize my fellow commissioners for questions. Curtis, do you have any?
Yeah, just a quick one for the applicant. Have you explored what can go back on the site relative to the COA process to get a sense of whether it makes financial sense to demolish versus restore and adapt to something more modern?
I can say that the plan is to put a new structure here.
Yeah, I
and
understand that.
in evaluating the existing home, that is really the only option we see. And so, and yes, we've started the process of looking through what new construction would need to look like and what it would look like. But again, not knowing the time frame for
I understand
when it can move forward, we don't want to spend significant resources. And this is not, we don't have a buyer, so, and we're not planning to build a spec house. We'd like to have someone to work with who knows what they want and what we can do. And so, and we don't know that until we know when we can remove the house. So, I mean, it's a kind of a little bit of a chicken or egg thing, I suppose. And so that's, we see this house staying in its current state for another year as really more of a liability and not helpful to the neighborhood, to be honest. And so that's the reason we'd like to move forward with the demolition now, move forward with the process of submitting an application, go through that process, and again, that's why we've made the request as we've made it.
Okay.
Curtis, any additional questions?
No.
Jordan?
No.
John? No. Rob?
Yeah, I've got a few. Chad, hey, a couple questions. So, trying to understand, you mentioned a year built that was different than what I had just seen on IMAPs, to be honest. What year do you believe the house was built?
My understanding from the historic research report is that it was built around 1960.
Okay.
The early 60s, I believe.
Okay.
Yeah.
Okay.
61.
Okay.
61, yeah.
Okay. And forgive me, where was that information provided?
It's in, if you're under tab 6, I provided a full copy of the
designation report.
The designation report under tab 5. And
Okay.
within that report,
It's
on
page 9.
I'm sorry, Colette, what page is it?
It's page 8 in that report.
Yeah, page 8. It says circa 1960.
Okay, thank you.
Any additional questions from the commissioners? All right, hearing none, I'll close the evidentiary hearing portion of the case and we'll move to committee discussion. Curtis, any comments?
Reviewing the amended application and the inspection report, like another house that we've looked at in a different historic district, I mean, this one is certainly in no worse shape than many that have been restored. And if these were other circumstances, that inspection report would form the case for a demolition by neglect hearing, not a COA hearing. My inclination would be to approve it with a demolition delay specifically so we can help the applicant explore the cost benefit of replacement in particular. Because I know many in the past have found that when they've gone down that road, it was more expensive to demolish than it would be to renovate and do an addition on it, if need be. That's my 2 bits.
Jordan, any comments?
The Wake County IMAP says it was built in 1959. I think just based on the evidence provided here, I think the house either needs to be demolished or significantly repaired. I I do have concerns about demolishing it with no plan for construction following. As we know, that interim time can last a long time. So I would advocate for a delay.
John, any comments?
Yeah, I think that to Curtis's point of, with the delay, 365 delay, it, I think, hopefully encourages the applicant to, one, look at other alternatives that preserve the existing character. Two, I think it also encourages the applicant, if the demolition is going to go forward, we will have the opportunity through this COA to be able to see what design they will come up with next, and therefore either shorten or sustain that length of time that we are proposing it be not demolished.
Rob, any comments?
Not too, well, I do. I'll try to keep them brief. Just, I agree with the general sentiment at the table, and feel that we've probably all seen other properties that have been rehabilitated that are in equal or worse condition. I do also feel like, you know, the district, this district is fragmented. You know, if you look at the HOD outline, it's fragmented, and there's, you know, it's not, and it's been fractured over time, as some of the commenters have presented. Sure, there's not a lot left, but I do think this is a character-defining home, and I think the house two over from it, 2208, which Ms. Hinton was here to speak on behalf of, you know, as her home, there's a lot of similar qualities. It's a very similar setback era home, and so, I mean, with the neighborhood already not as a like solid mass, but more, you know, oriented around Oberlin Road itself, I feel like we're here to preserve what's remaining. So I do feel like the house could be rehabilitated if there was determination to do so. So I agree with the idea of the delay.
Raz, I know, I think a majority of the commission here, this is their first demolition COA. You and I had a discussion. If you just want to provide some clarity on what the powers of this committee as it comes to demolition COAs, and also touch on the about, you know, before demolition providing construction plans and that guideline that we discussed.
Mr. Chairman, I'll try on the demolition question, the delay question. It's hard to make it clear and simple because the statute is anything but clear and simple. The language that is in the staff report is taken straight from the general statutes. It's the top of the second page of the staff report. Concerning demolitions, the committee is authorized to delay, but is not authorized to prevent demolition. The committee is authorized to delay for a period, not all or nothing's 365 days. It is for a period of time up to 365 days from the date of issuance. The statute says that if the committee finds that the owner would suffer extreme hardship or be permanently deprived of all beneficial use of or return from the property, then that maximum period of 365 days shall be reduced. There perhaps has been some evidence on the hardship. It was not directly alluded to. You would also have to evaluate whether you think there was a prima facie case made and evidence presented on extreme hardship. During the period, the statutory context for the delay period is, quote unquote, in order to explore alternatives to demolition. not just simply 365-day delay is imposed. It continues to say, in order to explore alternatives to demolition. The way the committee has addressed that in the past, and it's noted as condition 2, is that a committee member will be appointed to work with the property owner to explore alternatives during the delay period. So one action that has been taken previously is that the delay period has been imposed up to a maximum period of 365 days, and that a particular staff member or particular committee member will be asked to make contact with the owner and to explore the alternatives, and then following that, to make a report back to the committee, and based on that exploration of alternatives, to perhaps bring to the committee the question of whether the delay period should end and the demolition might proceed prior to 365 days. And all of that is just in the context of the statute saying that the committee is authorized to impose a delay up to 365, but it's not a 365-day period or nothing else. You can be a little more fine-tuned, the process, in order to explore alternatives. So that's what's going on behind the statute. It's about 12 lines, but that's, in a nutshell, I think that's what the statutory intent is, and that's the way you've tried to apply it in past cases. Staff may want to add something to that, but that's my experience in the cases that I have been familiar with. And on the second point concerning the submission of a site plan for the proposed reuse of the property, the demolition itself, because it's a special type of action and the committee is not authorized to prevent the demolition, only to impose a delay, that is a COA case in and of itself. And it's not linked with the submission of a development plan for the subsequent use of the property following any demolition. That is required. I mean, this is a property in the district, and in order for anything new to be developed on this property, that it has to be done pursuant to a new certificate of appropriateness application, and you start fresh with an entirely new process. The guideline does say that before demolition, not before the process may begin, before this committee takes action on this case, but before the actual demolition begins, submit a site plan to the commission illustrating the proposed site development. It does say submit a site plan, doesn't say go forward with all the requirements of the development approval process, including the COA. It just says submit an illustrative development proposal. So that would probably legitimately be a condition you impose, but that is something definitely short of going through the approval process and fully developing the future proposed use for this property. I know that's a little bit nuanced as well, but there's no direct linkage between getting approval for what is later developed on this property and this application for a demolition. They're two totally separate COA processes.
Mm-hmm. And I just want to clarify a little bit on that, Raz. When I brought that up, I was just referring to that process, even though it's completely separate, would be informative to this process in terms of the delay. That's all.
Exactly. No misunderstanding there, I don't think.
Do we agree as a commission that this house is beyond repair? I mean, do we have to agree to the delay, or can we deny?
We cannot deny the
demolition.
All we can do is delay the demolition. We cannot deny the demolition.
Okay.
I was just going to say, I mean, agreeing or not, as long as it's a majority vote, that's. But yeah, John is right. I mean, it's either approve or do a delay up to 365 days.
So there's not a deny.
No.
Okay. Thanks.
No.
And I don't think in the evidence we heard anything that in aggregate says that this house is, in imminent collapse or anything else. We've just heard that there's been a substantial amount of deferred maintenance and damage because of that. I'm happy to take a swing at it.
Proceed.
Okay. I move that based on the amended application, the evidence we've received in the public hearing, that we approve the application with a 365-day demolition delay and the following conditions. And I've done a whole pile of editing here. So one, that an RHDC appointed, that the property owner work with an RHDC appointed volunteer to explore all alternatives to demolition and/or salvage opportunities during the 365-day delay. 2, that the following be provided to and accepted by staff prior to demolition: a full documentation of the building with photographs and scaled, accurately dimensioned drawings. B, that accurately dimensioned scaled site plan locating the house and front yard site features. 3, that the tree protection plan be provided to and approved by staff, implemented and kept in place for the duration of the work. 4, that the site be promptly seeded and planted with grass following demolition until such time that replacement features are approved and work begins. 5, that the structure be stabilized to prevent further decay during the delay period. And just noting 6, that the applicant may return to the COA committee within the 365-day period to ask for a shortening of the delay based on additional evidence.
Motion has been made. Is there a second?
Second.
All those in favor signify by saying aye.
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 And I just note for the record, I vote no.
I will say that the dimensions site plan locating the house and site features that was provided by the applicant tonight as part of their materials, and it also includes a tree protection plan.
Okay.
All right, so the application has been approved by 4-1 vote, subject to the 365-day delay. That decision will be made official at next month's meeting when the next month's minutes are approved. So, thank you.
Do you want to choose a volunteer now?
Oh, we probably should. You probably, let's not forget it, not put it off.
Any volunteers?
My life is crazy in the next few months. But if, does anybody else have?
Nominate someone?
Only if they're not in the room, right?
You're talking about a member of this committee or a member of the commission who is not on this committee.
Well,
I think you've also done a duo, a pair in the past.
I'm happy to do it. I know we can't start anything for at least one cycle anyhow, so
Right.
that'll get me closer to Christmas, which would be good.
I mean, I can nominate myself. I'm happy to work with the applicant to get that done.
Okay.
Okay.
Thank you.
Thank you. Yes.
All right. Next is the Glenwood one, right? Okay. Losing track of time and space and everything else. New application number 3, COA 0106, 2022, 808 Glenwood Avenue. Ask that any applicant or presenter please move forward, come up to the podium. Introduce yourself by announcing your name and your address, please.
John Whalen, 808 Glenwood.
And I'm Courtney Whalen, 808 Glenwood.
All right. Will you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. I'll now recognize staff for their presentation.
All right, this is case COA 106, 2022 for 808 Glenwood Avenue in the Glenwood, Brooklyn Historic District. The request is to remove a non-historic window, alter original side window opening, and install new paired windows, and construct a new second-story side transom window. This is a view of 808 Glenwood as it stands from Glenwood Avenue. And a view of the north side of the house. The transom windows proposed to be installed up on the second story behind that initial front bump out. A view of the rear from the alleyway. And a view of the south side facade where the second window on the first floor here is the proposed window to be altered. Another overall view of the wall. And staff concerns are that the original window opening is in the front 50% of the house. Contextual evidence to support alteration was not provided.
All right, this time I'll recognize the applicant for your presentation.
So we have worked with an architect, Ashley Morris, on this project. One of the things we're doing is we purchased this home. We have 6 children. They're grown, but large family. We're adding on to the rear part of this home so that there's enough space for all of our children when they come home. In adding on to the back of the house, we're having to take away one back bathroom window, and that's why we wanted to add the transom window in the bathroom, just to add light to that bathroom. She had designed it. It's very close to the 50% line. The window would be in line with everything that has been used on the home. It's not, not incongruous with the way the home looks. It'll still look historic. It's just that it hit very close, and that's the only spot we can put it to get that light in the bathroom. On the other side of the home, where we wanted to put the twin windows where there's just a single window, again, it's right on that line. You can't see either one of those windows from the front of the house when you look at the house, even if you kind of try to walk to the side. The houses are very close together. The house to the south side of our home was built in 2000, and it was, in 1999, it was a double lot. It was divided. There were 2 non-historic homes built, and it's a very tall house built very close to the lot line. It takes away a lot of the natural light on that south side of the house. So that room, and Ashley had agreed, it's very dark because of what is right up next to the house. So we don't actually get natural light. One of our other concerns, and an area that we've been focused on, is the 30 stories building they're planning to put on West Street, or hoping to put on West Street, which will also block light coming toward our house on the south and east side. So to add a little bit more natural light was really the goal of adding that window, and we understand it's at that 50% line. It wasn't to change the look of the home. We love the historic home. We love the character. We don't really want to change anything about it. We just wanted to add a little light.
Anything else?
No.
Okay. Is anyone present who wishes to speak in support of the application? Anyone present who wishes to speak in opposition to the case? Anyone present who has questions or comments on the application? Hearing none, we'll move to commissioner questions.
None.
All right. Jordan?
Yes. Have you considered skylights or solo tubes or other sorts of lighting elements opposed to a window?
On the south side of the house, that's not possible in that room. And, there's no way to get light down. It's a first floor family room.
Right. What about the bathroom on the second floor?
We have asked Ashley about that. The better option, and she thought it was very non-obtrusive, would be to add the transom over the bathtub in that room.
No other question.
John?
I've got a general question. Are we looking at the side of this house? Because this is street-facing district.
First 50%, John.
Oh, it's first 50%.
So, and there is a dash
Yes,
provided.
okay.
So
Okay.
both of them fall within, and I will grant it, barely within the
Yeah.
50%, but it is within 50%.
Gotcha.
So that line is provided.
Gotcha. A little just architectural lesson here. aperture size does not necessarily mean more light. More apertures do. And so my point to that is that you could still have the same amount of daylight, but not necessarily have a double stacked window. And still get because you, especially when that window is in the center of the room versus at the more closer to the side walls, because you're lighting surfaces then, not just the space. That's my diatribe. With that, I point to the elevation on the south side. Nope, north side, my bad. Am I right?
Yeah.
Yeah, on the south side. Thank you, where the,
It's slide 20 of 23 of the application.
yes. Those two, the windows above, the windows above on the.
You're on the
proposed
south side.
Right side, yeah. The windows above, if you carried those windows straight down and kept it in line with the other windows, which is typical of this house, you would still have two windows in that same room. And they would be closer to the walls. Just saying on that front. I'm not a big, the reason I'm bringing all this up is because of the double window introduction that I find a bit inconsistent. That's
Can I just ask you a question?
Sure.
So you're saying you would prefer a window at one side of the family room and one at the other?
Yeah.
But
So-
we were
so the-
trying to stay within, that 50%. So that's truly why we went with this twin window. It was less of a change to the actual house. Because we have a window there, it was just doubling the size of the window. And we do have that same window, twin window, on the front of the house, on the front porch.
So, and I think one of the staff concerns was about, so typically the grouping signifies some level of hierarchy. And so it being on the front gives it some hierarchy to the overall house. I recognize there is one on the rear of your house on the second story. Right. There's one grouping. So there is precedent for it elsewhere on the house, but really on the part that affects the street side overlay, there's really only the pair that's beneath the front porch. John,
sure.
So just to clarify, I had thought the same thing.
How about with these guys here?
Yeah,
Okay.
but about having them more like
Aligned.
And I know we're not supposed to give design feedback, but I feel like that's more in the character of the house, which if you look at the side elevation, it's a bunch of individual windows.
Those right there. Just carrying those two down. And granted, I take that as an editorial on my part. It's just that in my architectural world of understanding these types of this construction character, they would align if they were being built today. If that wall was being built today, they would align. That's my 2 cents.
Any additional questions from the commissioners?
I've got a few.
Go ahead.
So for one, somehow I overlooked this house, I think probably because of all the new houses near it. It's a beautiful house.
Thanks.
It's really amazing. It has some really nice features, especially the diamond windows kind of up in the eaves. You've got a few of those. So am I understanding correctly that there is a forthcoming COA for a further addition?
No, it's all, there's no change to the side of the house. We're just doing a 2-story addition. It's just going out 12 feet from the back of the house. And on the second story, we're building an office and an extra room. And it won't be seen, and it's behind the 50% of the front of the house. So it goes straight back. There will be no change in the sides of the house.
Okay. Okay. No further questions.
John? Any questions?
No questions, thank you.
Jordan?
No questions.
Curtis?
Nope.
All right. This time, we'll close the evidentiary portion of the hearing and move to committee discussion. Any comments, Curtis?
I think what they're proposing is congruous with the character of the house. I think it's consistent with the house. I'm noting on the elevations that the second floor windows are not aligning with the first floor windows. And while I understand what John was saying about the double window on the first floor, the double window is going in the footprint of an historic window, which to my mind means we're preserving more of the original fabric.
I see what you're saying. I didn't figure
And I think that's actually, for that reason, a better choice. But I would approve this.
Jordan, any comments?
No.
John?
No, that's good.
Rob?
I appreciate your saying something, Curtis.
Okay.
I have trouble with the window on the left side, the transom in the shower area. It feels awkwardly placed, and almost every window other than the special windows that are kind of a square with a diamond within them, every other window is a portrait format. There's no horizontal, so I don't find it to meet the character of the rest of the house. I also have to unfortunately disagree that it's not visible from the street, because I think it is. So I would love to see a skylight in the rear facing part of the roof, and I think that would honestly be a much better space, and it would definitely limit the visibility while still accomplishing the objectives of bringing light into that space.
What he said.
I looked at that too, and what I decided when I started looking at the elevation and what it did is it actually continued the pattern of the first two windows as far as stepping up, almost like it's following the staircase. And that's why I felt comfortable with it. Frankly, I felt that was its rationalization on a design level, but I understand what you're saying.
Only other comment is I can agree with both John and Curtis on the south or right side. Both are good arguments, so I would be inclined to approve as submitted on that south-facing pair of windows.
Are we in discussion? Yeah. Now Curtis has got me thinking about that stair-stepping thing going on, and it does make, when I look at, I think the bubble makes it, the bubble around the window.
Oh yeah, it makes it wrong,
Screws me over.
Yeah.
I think for me, it's that it's engaged with that freeze board.
Right.
It just,
Yeah. Not any way to lower the thing, is there?
and I think the orientation of it is foreign.
Yeah, I agree. The horizontal. But when you consider it that it's a transom over, but see, none of the other windows have transoms, so you wouldn't know that.
Had it been on the rear facade of the house, we wouldn't even be talking about it. Yeah.
Right. Is the 50% line right through that window?
It's just beyond it. There's a plan view,
Is that
John.
it? Right there?
Yeah, the rear facade is on the back 50%, isn't it?
Would we be satisfied with additional context from the district for similar transom windows in the 50%?
Say that statement one more time, Jordan. I'm sorry.
I said, would we be satisfied with the historical context from the district with some windows of similar character in that front 50% for the second floor bathroom?
I don't know if I would, because I still think, precedent does not have to rule the day.
Right.
And I feel like this house has a wonderful, strong language of vertical windows. And, I think I can get behind the pairing of two vertical, 2/2 windows, but I don't know about the horizontal transom. I would probably want to find another solution there, is what I would like to ask for.
We could put that in as a condition.
A window of a different orientation, perhaps?
Or a roof window.
Or a skylight.
Or a skylight or a solo tube or something.
Another solution, basically. Don't dictate what it is, but just basically ask for a different solution based on our criticism that it's out of character.
I mean, it sounds like what we're saying is there's not a compelling enough reason to break this rule at this moment.
What's that?
Is that right?
I think we would need to deny that portion of the application. That would be the condition. Staff, is that correct? I might need some help on.
We're in committee discussion, so I'll limit my comments and point to
sorry.
Raz. But in effect, to condition that they not build something they're requesting to build and build something else instead, I think that the effect would be to deny it.
Okay.
I don't have anything to, I think Aaron makes the point well.
Okay.
Honestly.
Is there some way we can defer it? Just a condition that this defers, so it gives them an option to resolve it without?
Let me ask you a question before we go down that route.
Sure.
If a vertical window was proposed, knowing what would be the limitation here, and I'm trying desperately not to get into design by committee, but if a more vertical window was proposed, knowing that there's a bathtub behind it, does that, and knowing that it's going to want to be at an elevation such that it might still engage the freeze board, would we be any happier? I mean, because we actually have approved even dummy windows on houses for bathrooms as a way to get there, and have something where there is a really strong symmetry. I don't think this has a really strong symmetry, so I don't think that compels us in that direction. But I'm wondering if the alternative, other than a skylight, would be worse than the current solution.
I don't, because if you look at the second floor elevation, as you go around the property, Curtis, all four sides, I agree that the windows vary in size, and there's that kind of stepping up on that particular elevation. But those that are sort of engaged, that are hosted as part of the second floor, do have a consistent head height.
Gotcha.
And it's not engaged with the freeze. It looks like there's
there's
at least a board.
Yeah, a board or two. Yeah.
Or two, and
For the odd-shaped windows, yeah.
Yeah, and there are a few small vertical windows, including one on the front.
There is one on the front on that corner of the house. Yeah.
I think the trouble that I'm having is that they're essentially asking us to approve two windows in the same condition, and we are approving one and not the other at this moment, it sounds like, which is dangerously close to editorializing to me.
Well, we're approving two windows, the one on the front and the one on the side. Aren't we?
Yeah,
No.
just two sides, and they're both.
There's
within
only two. There's two changes that are subject to the COA. The one on the south side, which is becoming a grouping of two on the first floor,
Right.
and then the one on the north, which is the one you're looking at, which is the left side, which is the transom above a bathtub.
But what, I thought we were,
And
that already exists.
oh, that already exists. The windows got replaced, because I saw a picture earlier where they were doors.
That was part of prior renovation project.
And essentially the reason this is before the committee is because of the 50% rule that they are both within.
Correct.
So, you know, at the risk of being too blunt, it sounds like we like one window and we don't like the other one, so we're only going to approve one.
I might ask at this time, Raz, if you can weigh in on the committee's ability to render a decision that is deny in part and approve in part.
Well, this has been discussed with the Raleigh City Attorney's Office, and it's to be discouraged. I mean, a condition, that's not what conditions are supposed to be all about. Conditions are supposed to be just slight mitigation measures that improves a proposal that you might otherwise have difficulty with, but it really is not allow in part and deny in part.
Okay.
In its essence, and this is really just taking the two proposals that are up before you. You know, I would just suggest that you might want to give a clear indication to the applicant what issues you have with the one window. I mean, the standard in the guideline is for less significant facades, pattern of proposed window openings should be characteristic of and complementary to the historic building and the historic district context. I mean, that is the case that the applicant has the burden of producing evidence on that point and making the case. And that's something perhaps the architect might be in a position to do quite well. But I honestly would suggest that giving that clear signal to the applicant of where you feel that there's a shortcoming in the evidence, and defer, and then either see if they are inclined to alter the design any, consistent with some of the comments that have been made, or if they'd like to present evidence to make the case.
Or option 3, amend the application to remove the one window.
Well, that's exactly. An amendment to the design, to the proposal.
Yeah.
That's just a thought about one way to handling it, but I think there is a problem with allowing half of the application and denying the other half of the application.
I'm inclined to defer.
Yeah, I'm more inclined to defer simply because I think that even the owners have spoken about, they mentioned this skylight idea to the architect, but they have, it seems that that hasn't been produced yet to study or see if it's an option.
How about we ask the applicant what they would prefer?
Fair enough.
Would you like to
hearing where it's going?
Hearing where the committee is discussing. Would you like to provide any input or response?
What do you think?
Yeah, I would prefer that we get the south side approved, and we'll look into a skylight that faces the south side.
I mean, if we could do that instead of having to go through this process again.
Put another way,
you know,
amending the application
or
to delete
if honestly, if we could do a minor work approval, which is what Ashley tried to do initially, because she thought that it was so close to that 50%. She tried minor work approval. Maybe we could get an approval for the south side windows and then change the design for the window, maybe to make it, you know, do a diamond window or something that gets approved that's small enough to get the light into the bathroom instead of going through this whole process again.
So just to have some clarity on the record, you want to amend the application for the two south side windows?
The north. Single north window.
Single north window.
Delete it.
Yeah.
Correct?
Correct.
Okay.
For the record, the installation of skylights is typically approvable as a minor work.
Oh, okay.
COA, that's how it's listed in the list of work. So is alteration of windows typically. So we elevated this from a minor work. But if the committee can give clear instructions on what, you know, they find to be congruous with this potential change in window, I think that it could be handled as a minor work, and certainly the skylight could as well.
Well, and to summarize back, and correct me if I'm wrong, guys, what I'm hearing is the objection to the north window is its engagement with the frieze and its proportions.
Correct.
You prefer it more to be a vertically proportioned window to be congruous with the rest of the windows on the structure.
Correct.
Okay.
Would you like to follow that up with a motion?
Yeah, it'd be a really easy motion.
Okay.
Okay. I move that, based upon the amended application and the evidence presented during the hearing, we approve the application.
Motion has been made. Is there a second?
No, because we've deleted the window.
Second.
All in favor, say aye.
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 Any opposed? Motion carries unanimously. Thank you for your time and application. The official decision will be made next month when the minutes are approved, and you'll be informed at that time.
Thank you.
Thank you.
Thank you for your time.
All right, next is new application number 4, COA 0107 2022, 1031 West South Street.
Demolition.
Ask that the applicant and anyone who will be presenting on the applicant's behalf, please introduce yourself by stating your name and address.
Ulrich Hauser, representing 1031 West South Street.
Lawrence Graham, attorney from Manning Fulton. I'm representing the homeowner who can't be here tonight. We're at 3065 Glenwood Avenue.
All right, at this time, we'll swear both of you in. Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? I do. Thank you. This time, we'll recognize staff for their presentation.
This case is COA 107-2022 for 1031 West South Street in the Boylan Heights Historic District. The request is to demolish a historic shed. You can see here on the map that the property outlined in red is 1031 West South Street. Also swinging around the corner along the same alley is 1103 West Cabarrus Street. The applicant has been working on significant rehabs for both of these projects via minor work, and the proposed shed removal is located on the shared property line between these two properties. So this is a view of 1031 West South Street from West South Street, and a view of the other side of the house looking back toward the rear yard where the shed would be removed. View of the rear of the main house. And this is a view looking up Cabarrus Street, the 1103 West Cabarrus's driveway toward where the shed was located. I should note this is an after-the-fact application. Sort of near that tree or pile of bricks is the previous location. And looking back toward West Cabarrus Street in the rear yard of 1031 West South. And an overall view of that shared rear yard area. And the back of the Cabarrus Street house as well. Another view from that alleyway. Staff concerns are that the age of the shed is not definitively known, but all available evidence we've been able to find suggests that the shed is historic in nature.
This time, I'll recognize the applicant for their presentation.
Thank you, Mr. Chairman, members of the committee. Like I said, my name's Lawrence Graham. I'm here on behalf of Dr. Catherine High. She's the homeowner. I'm an attorney at Manning Fulton here in Raleigh. Kathy wanted me to send her regards. I just have a few things to say on her behalf. She regrets not being here. This property in the Boylan Heights district are very, very dear to her heart. Kathy's great-grandfather, Lacey Rankin Thacker, he built a number of houses in the Boylan Heights district. Her grandmother, Ernestine Thacker, grew up in one of these houses, graduated from St. Mary's in 1921, was married, and eventually moved into the house standing on 1031 West South Street, the subject property. Miss Thacker, she called that property her home until the day she died in 1989. The property eventually made its way into Kathy's ownership, and unfortunately by this time it had gone into a lot of years without adequate care. So Kathy began the process of restoring the property, which is what brings us here today. The removal of the dilapidated shed, as Ulrich will expand on, is goes to Kathy's vision of restoring the grandeur of this beautiful historic property. Kathy is committed to complying with the committee's requirements, and she just graciously asked that the committee approve her certificate of appropriateness for application of the removal of the shed. With that, Ulrich, he's the real brains behind the organization and the process, so he will happily answer any questions you have, and he has a brief presentation for you.
Hi. Again, I'm Ulrich Hauser. I'm an architectural designer working on the projects. Project houses being 1031 West South as well as 1103 West Cabarrus. My wife is...
Sorry, could you speak into the mic? I'm having some trouble hearing you.
Oh, excuse me.
Yeah, thanks.
My wife is Catherine High's sister, so there's the family relationship, and we're continuing, or at least that's what we wanted to do, continuing the family work on the properties, and the house has been and will stay in the family ownership. The reason why we removed the shed was there was no record that we were aware of that there was ever a permitted structure or any record that when it was built or exactly to what specifications it was built. I know that later on in the process there is a mention of a shed as we found out in the tax record. And that's all we know. There's a simple line in the tax record that attributes that shed to 1031 West South Street. However, that shed is not, the way it was located was not properly on the 1031 West South Street property. It was actually straddling 3 property lines. And so that's one of the reasons, of course, why one way or another something had to happen with that structure. On top of that, the condition of the shed was such that it was in really bad shape, as you've seen in the pictures that we provided with the application. So that's why we said, okay, there's really no reason for that shed to be part of that remodel process, and there's no contribution of that shed to the historic character of that neighborhood, as in there is no other shed like it that we are aware of anyways in any of the Boylan Heights. There are other sheds, but none that were constructed like this one. So there was no real reason to consider a historic contribution or a contribution to the historic value of that neighborhood. That said, that's why we didn't went through the application process before we actually demolished the shed, because we didn't know that it actually required a COA, because, as I said, we didn't even know it existed in any record.
All right, thank you. Is there anyone present who wishes to speak in support or opposition to, or has any questions or comments about the application? Seeing none, we will move to commissioner questions. Curtis, do you have any questions?
No questions.
Jordan?
No questions.
John? Rob?
I always have questions. Sorry, y'all. Always. So I did notice on the 1924 Sanborn maps that there's a structure that it exists on the 1924 Sanborn maps. And what I think I heard you say was that you don't believe this was the same structure based on its location. It's difficult to say, because it looks like on 1924 there was not a property line between the 2 Cabarrus properties. So, and in your COA you've located it based on the intersection of those 3 properties. Okay. So is it fair to say that you don't think it was that structure from that time, that it was maybe from a different time?
Probably not.
Okay.
I mean, hard to tell, but probably not.
Okay. That's my only question. Thank you.
Any additional questions from the commissioners? All right, hearing none, we'll close the evidentiary hearing portion of the case and move to committee discussion.
Well, I have heard from what we see and hear that the shed I guess in present tense, since we have to handle it that way, is substantially deteriorated beyond repair. We have heard that it has not been mentioned in the designation report, and therefore as a structure itself isn't necessarily contributing to the character of the district. So I have no problem approving the demolition without delay based on that. Go ahead.
I respectfully disagree that there are not other similar structures. 324 Cutler has a garage that is on the McCulloch side that was for the sake of this discussion, it was falling over.
Okay.
And I don't know whether there was a COA on that or not, but there was careful restoration, and it had a very similar roof structure that was 2x4s laid sideways with just tin roofing across it. There's also a similar one, a similar structure to this. It's barely in the district, but it is in the district. It address is 640 West South, and it has a garage facing Florence. It's kind of like an alley at that point, but it's a very similar construction type. So I think they were a little more common than maybe is being characterized, to be honest. I mean, I understand that it was in disrepair, but
Do you think they contribute to the character of the district?
I tend to believe, yes, they do. Not when they're falling down. That's not what we're trying to push. But the neighborhood does have quite a few small structures, mostly along the alleys. But the Cutler one that I'm thinking of was the structure was just facing the street and not the alley itself. So I feel like it had similar character.
Mm-hmm.
I have to ask our commission, would we be approving this demolition if it wasn't already done?
Well, it makes me think that, or realize that I did have a question for the applicant.
That's fine. Go ahead.
Does the owner have any survey between the time that she took ownership and the time of the demolition?
Yes.
And is that building on that survey?
Yes. Well, no, sorry. Survey was done after the shed removal.
I see. I don't know the answer to your question, Rob. Maybe.
It's my belief that it was probably the structure that's on the Sanborn Max.
Yeah.
And because those are somewhat imperfect also, they're not the same as a surveyor's drawing, nor do we have a surveyor's drawing now. I don't know that
in my opinion, that proves that it's old, but not necessarily contributing to the character. And it is off an alley. It's right sort of mid property. Yeah. So it's not like it even addresses the alley. It was just built there,
I see your point.
I'm also not necessarily convinced that a few sheds does a character make, although the neighborhood does have a number of small structures. They are of varied type. So maybe it both
It's a fair
is.
I think it's a fair position.
Maybe it both is and isn't part of the character. I don't know.
Can we make a motion? I would like to make a motion that, per the applicable standards and evidence in this hearing, as well as testimony and facts entered, we approve this application and waive the 365-day delay and no other conditions.
Second.
Motion has been made and seconded. All those in favor signify by saying aye.
Aye.
Aye. Any opposed?
Aye.
The motion has been approved 4-1 to proceed with demolition of the shed. That decision will be made official at next month's meeting when the minutes are approved, and then you will be informed.
Thank you.
Thank you.
Thank you.
Last but not least, new application number 5, COA 0120-2022, 521 Elm Street. Ask that you please introduce yourselves by stating your name and address, please.
I'm Lisa Finaldi, 521 Elm Street.
And Brian Starkey, 521 Elm Street.
And Mr. Chair, just to note, I live within the 100-foot radius of a proposed thing, but this is going to color my.
Thank you for saying that. I've actually reminded me that I've forgotten to ask that for like the last 3 or 4 applications, but thankfully I have commissioners like you who will bring that up on their own. So you saved me from that. So moving forward, Curtis having indicated that he does live within the 100 feet of the property, is there any, but still feels that he can fairly decide on the case? Is there any commissioner who objects to Curtis proceeding? Neither do I, so we'll move forward. Okay. This time we'll swear both of you in. Will you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. This time I'll recognize staff for their presentation.
Hello, everyone. Last but not least, we have case COA 120-2022 for 521 Elm Street. This is in the Oakwood Historic District, and the nature of the request is a change to a previously approved COA, and that was COA 170-2021. I did not include any photographs of the property here because this was, you may recall, first a demolition application. The new construction application was COA 170. And this is an interesting discussion for you all this evening. In previous times, we would have heard as a committee review of conditions, but as we've been reviewing our policies with the city attorneys, we have a need to more formalize and legalize that. So this is coming to you as essentially a new application to change a small portion of that previous application. And the change is to the material. The request is fiberglass, which has not been previously approved by the committee, nor has it been asked for. So you're reviewing a new material this evening. We can start with your questions. I have printed out a guide that was prepared in 2009 for how to review alternative materials. If you would like some guidance, the guide was prepared by the National Alliance of Preservation Commissions and was included in the Alliance Review, which is their quarterly publication. So if you want some additional thought process for how to approach this, we can turn to that. But yeah, this is a new one for you.
I think any additional help would be appreciated.
Sure.
Are there samples of this? Like material samples?
Did you bring a sample? No.
We did not, no.
What I see in your notes here is that fiberglass doors have been approved.
That's correct. So fiberglass doors have been approved for use. So far, it's been requested on rear facades on additions. That has been found to be congruous. But the request for windows has not yet appeared before you until this evening. And this is also a fiberglass door on a front facade. It is new construction, so you can take that into your consideration.
But it is globally for all of the windows and the doors on this.
That is correct.
On this
yes.
project.
And Curtis, to your point, the rear door for fiberglass was first approved in 2012 at 501 Oakwood.
Okay. And was it conditioned on being smooth as opposed to grained?
That is exactly correct. The
Okay.
smooth texture and painted finish
Okay.
were conditions of that approval.
Are there any additional questions from the commission for staff?
Just walking through the flow chart would be,
Okay.
I mean, were you prepared to talk to us about that now, or do we need, or no? It's not, I'm sorry, it's more complicated than I was expecting it would be.
Yes, yes. So there are 3 evaluation thought processes shown here. The first 2 rows are if it is repairing or replacing an existing current feature on a historic property. That middle row, the third one, is for introducing a new material on the entirety of a property. And the last 3 are introducing new materials, features, and systems. And each one is kind of things to think about, things to consider. The second column is the Secretary of Interior standards, which tie to those different thought processes. The third column is social and cultural responsibility as it relates to the Secretary of Interior standards. And then the last 2 columns are environmental and economic responsibility considerations as you consider the material.
Thank you.
And as a practice, we have established precedent this way, differentiating new construction additions from historic. Okay.
Wes, can we ask the applicant a question, or no?
I was going to provide the applicant an opportunity just to make a presentation if they had any, and then we could ask questions.
Yeah, we have just a couple statements to make as you are digesting the flow chart. Again, I'm Brian Starkey. My wife Lisa is here. We've been in Oakwood since 1986. We have lived in 4 houses. We have renovated 3, and we're very excited about this project. All things being equal, this is our last house that we will live in Oakwood. Our request tonight is pretty simple. It's really about flexibility and the ability to respond to what we perceive to be potential supply chain issues. We did originally submit an application for this project to be for windows to be wooden but aluminum clad. We did not submit anything specific for the door. It's still our intention, always has been, to have a wooden door, but that our investigation into the options of wooden doors is we've come to the conclusion we're a little bit limited. We're not really of a mind to entertain tropical woods from an environmental standpoint. So we really are talking about the cladding and having the opportunity, the flexibility to respond to those issues if in fact they present themselves. We do feel like the fiberglass clad windows and doors are very visually congruous, similar. They are wood, so the cladding is the issue. They both have a smooth texture. So from that standpoint, we feel like they're the same. So they are, wooden doors and windows. The issue or the request is regarding the cladding of them. I was just looking, and that's really simply our request. I was looking at the flow chart a little bit, and the considerations in the second column. This is new construction, so it is a brand new house. It's not a contributing structure in the neighborhood. So with regard to property significance, I think that plays into that. Location, windows and doors, it is global, so it is the whole house. We are not right on the street necessarily, so we're set back a little bit from the street. So I think that should play into it. The windows are distinctive features. The visibility, again, we're at some distance from the street, not right up on the street. From the standpoint of repairability, I think these are modern materials, but I think the visual characteristics, the resemblance to other doors and windows in the neighborhood, I think we are compatible and congruous. I'm looking down that list again. Visual impact. I'm sorry. Did somebody? Yeah, there is cost associated with the supply chain issues, a related concern there. But yeah, we're asking, for that flexibility. Don't feel like it's a visual issue. If we can find a wood door that meets our original design of the house, that's certainly the direction we want to go. But we just simply, yes, are asking for that flexibility for the cladding of both windows and doors.
Thank you. Is there anyone present who wishes to speak in support or opposition to, or has any questions or comments about the case? Seeing none, we'll move to commissioner questions.
None.
Jordan?
None.
John?
You don't have samples of what the fiberglass is relative to the clad.
I do not.
Right, right. But you submitted the specs for the fiberglass?
Yeah.
Yes.
It's a Marvin product.
Oh, okay.
It is part of the application, John.
Gotcha.
I think you answered it, but it's really about flexibility and cost, lead time, supply chain. The only question I was going to have is why, because it seemed like Marvin provided a similar product that was aluminum clad, an aluminum clad wood window, which,
significantly in price. And also, we were also looking at a different window, a Windsor window, and some of these things are 30 weeks out because of the glass problem. And so, we want to make a decision when we're ready to purchase.
understood.
Yeah.
Second question, how did this come to our attention?
So the applicants submitted their conditions of approval, of which included specifications for windows and doors.
Okay.
And since fiberglass has not been previously approved as in windows or a front door,
Right.
it's not something that we could.
But this was something that they didn't get caught. They basically submitted.
Correct,
Okay,
yes,
thank you.
exactly.
That's what I wanted to find out. Were you trying to go around us, or were you trying to work with us?
No, we cannot get our building permit until we get the
Gotcha.
placard, and these are these details.
No further questions.
Any additional questions? All right. At this time, we'll close the evidentiary hearing and move to committee debate and discussion.
We basically set a precedent here.
Yes. My humble opinion is, since we've approved fiberglass doors, and it is a material that's a smooth finish and is going to read like any other painted similar material, that there's no compelling reason to deny a fiberglass.
There are considerably more windows on a house than a door, and
Sure.
I mention that because doors are frequently altered in their existing opening, windows less so.
They tend to live, yeah.
I believe fiberglass could provide a similar sight line. I do worry a little bit about precedent, but more so about just environmental characteristics of sort of a natural material. At least an aluminum clad window is a it's a less harmful to the earth process than fiberglass. maybe not by much, but
I was going to say the cost, the refining of aluminum and milling that, it has to be kind of painful too.
It appeared that both Colette and Raz wanted to make a comment, or if you still wanted to.
Maybe Raz will elaborate on this, but in previous requests for new materials, you can include in your decision, specify the facts that make this particular installation different from other future potential applications. Setting precedent, it would not be blanket precedent. I mean, finding that this is an entirely new construction, it's sited further back from the street, adding facts like that, I think can help to potentially ward off
approving with certain facts that would distinguish it from a potential future case. So you're not necessarily setting blanket precedent, but if a future application came along down the road, members could say, well, this is different than that for this reason. Here we might approve it, but then later on in a different case we might not.
Well, and to my point that I kind of keep harping on, quality is part of that for me, because there's bad fiberglass and then there's good fiberglass, and I don't know which one we're talking about here. So
I did do a little research, John, based on the application, and I do feel like it is a high quality product. I mean,
well, then I think we should make that part of the precedent not precedent setting, but why this can't go down in precedent is that we are looking at a specific quality of that fiberglass, which most mirrors a wood window.
And what I am seeing is that on the submittal drawing, we have nice sharp corners, cleanly defined corners as opposed to rounded corners in the proposed submittal. So that kind of reads to it reading like a wood window as opposed to reading like an extruded clay object or something.
I would like to make the condition on if we approve this, that a sample has got to be provided that staff gets to review. Is that fair?
Brad? Go ahead.
You could certainly have a sample provided and reviewed, approved by staff, but to be recirculated amongst you, I think.
Oh, no. I'm not saying that. I'm just saying that it would be in staff's hands to review it. Just so that we do set a precedent on that front, that we are reinforcing a quality issue relative to the material.
The nearest example that I can think of is potentially the aluminum clad windows. When that was originally approved, ensuring that there are flat seams, that it is a paintable product. That is something that we continue to look for, that when we approve window conditions. Those were things that a previous committee decided that would make a aluminum clad window congruous.
And I think following that same guideline for this process for the fiberglass would be appropriate.
Raz, do you have a comment?
Just a comment, and it's maybe not necessary, but the legal issue is still congruity with the special character, not whether we have allowed this before or not allowed this before. So I think y'all are aware that the concern for precedent is commendable, but it's not at the top of the hierarchy of legal standards. It's just trying to have good governance, really, and good decision making that is consistent. But that's not the legal issue. So just keep in mind that we're dealing overall with congruity, and previously you found that the doors, subject to their being clad in metal, were congruous. So we're focusing the issue. We're looking on an extremely relatively minor detail, but that context of overall congruity is where you need to keep in mind
the congruity of what I'm speaking to the congruity of what they proposed versus what they now want to do.
I understand. And there was a guideline relating to substitute materials, which is what you evaluated initially.
Right.
And now you're just looking at it with different facts.
Correct.
Now, knowing that in our new motion method here, we're not proposing findings of fact, what I've heard from us as a group is that the facts that are relevant to this approval is that there were previously approved fiberglass clad doors, that this is new construction, that the proposed structure is set back from the street substantially, that the windows, the proposed windows have flat seams, that they're paintable, and that they have sharp corners in their detailing. Is there a fact that I have missed that we want to make sure gets into the record?
I'm very uncomfortable with this without a sample. I'm sorry.
Yeah, I am too.
I think, and I'm sorry to the applicants to say that. I just, you captured all the conditions, Curtis. I'm just.
Well, I mean, I think these conditions, if we're asking a sample to be provided to and approved by staff,
Yeah.
give the staff criteria for approving it.
That's the part I think we need to make sure we state in the motion.
Well, I wonder if aluminum clad windows have specific criteria that need to be met, or if they are simply consistent with, the historical nature of other windows that might exist.
Well, I think as staff explained, breaking down what the clad window, what its qualities were, what its specifications were, is what we're kind of leaning towards, not just that it's a clad window, but that it have the seams, as we talked about, and the paintable surface and that kind of stuff. That doesn't necessarily specify a given material. It is a performance spec, not a material spec.
Mm-hmm.
And that's where I think that's where we're coming from, is that this needs to be on a performance specification, not a material specification.
Well, and something else we've talked about in the past when we've looked at some kind of proposed new material or their shadow lines.
Mm-hmm.
They have similar shadow lines to the historic
Yes.
material.
Yes.
And so that would make sense to get in there too.
Yes, exactly. And with that, I'm waiting on Curtis.
You're waiting on me?
Yeah, because I wanted to let you finish writing down what we're going to say.
No, I honestly, just by saying that, we've got something that's now can be read into the thing as a fact.
Yeah.
Okay?
Yeah.
So, I mean, if I'm going to make a motion, I move that the application be approved with the condition that the sample be provided to and approved by staff prior to construction.
And that its approval be based on its performance.
Right.
Make sense?
Is that too vague?
Well, okay, what I mean by performance is those criteria by which you have set up aluminum clad windows in the past, same criteria for this sample.
So the aluminum clad list, I will read it to you. Smooth painted finish, not an anodized finish. Seams are flush, not pronounced, and not significantly more visible than the seams on an all wood window.
Perfect.
Copy those.
Yes.
Yes.
I don't think the motion needs to be restated, but motion has been made with some clarification, and
which I accept.
Which a friendly friendly amendment to the motion. Is there a second?
Second.
All those in favor signify by saying aye.
Aye.
Any opposed?
Aye.
That you're voting aye. Okay, aye. All right. Good. Sorry.
Nay. I'm sorry. Yeah. All opposed, nay. Yes.
All opposed?
Correct. Nay.
Okay, good.
Thanks.
Awesome.
I need legal counsel. I'm sorry.
Motion has the application has been approved, subject to the conditions as set out by Curtis and Colette. The official approval will be communicated after next month's meeting when the minutes are approved. So,
Appreciate it.
thank you.
Thank you all.
Thank you, folks, very much.
Thank you.
Thank you, Kurt.
All right.
Amazing patience.
Yeah, really.
Brad, what's that?
Thanks for your amazing patience.
So,
Amazing what?
Patience.
Oh. It's not my first rodeo. at a public meeting.
Cleared out our emails.
Yeah, we had some stuff. We got some stuff.
We got some work done.
Thank you again.
So we are not done yet.
Okay.
I see under item D, committee discussion, we need to discuss December caseload and meeting times. I've heard that next month will be a bear.
We have bad news.
Yes, it will. All right, so we have 13 cases submitted for next month. As a reminder to new members, typically this committee meets on the fourth Thursday of the month, so it's a monthly meeting, but that typically lands us right on the holidays at the end of November and December, so we combo it into one early December meeting. Somehow everyone found out and came at the same time. I'm not sure, but it's a heavy caseload. And there are some significant requests being made, as well as a couple of standard requests, but there will be certainly lots of anticipated discussion if tonight is any indication. So there were, 5, I think, tonight, and we're going to more than double that.
So the next meeting is in December.
December 8th.
December 8th, okay.
We want to hear from you all. We've debated this. This has happened. December 2020 was a similar meeting where we picked out a second date that worked for committee members and let applicants know that we were only going to a certain time and we would get to all we could, and those that we couldn't get to would be next up for the second meeting date. What we want to hear from you all is how you, as the current committee, are interested in handling this. If you want to essentially power through and go until it's done, whatever that may be. To be honest, I'm not sure that would be fair to the 13th applicant, although we can try to advise better about what hour they could show up at the meeting, but there's never any guarantees there. So we're just interested in hearing what the committee is most interested in doing in terms of the caseload for scheduling.
Well, and I am not available on the 8th either. So Rob, you would be chairing. But I could be available if there's a second date, which I would think, following along with what was done back in 20, setting a time like this is when we're stopping, or whenever we finish, the closest application that's done to that time, stopping and then proceeding to the second date. I think 13 is way too many to do on one night, because that could go. I mean, let's see, we did 6 or 7 today, and we went 3.5 hours. So at this pace, it would be another 3.5 hours, which would take us into the next morning. So I don't think that's a good idea. That's not good governance, I don't think.
So we did a preliminary look at possible availability for a second date. There are not many other evening slots available after the 8th if you wanted to schedule, a similar time, 5 p.m. I guess we can put out some possible dates if mornings are available. That's what happened in 2020. We did our regular 5 p.m. time, and then the next meeting was at 9, I believe, 9 to noon.
Essentially, I think it was a Friday morning, and it may have been completely subject to what committee members had available. It's not, chosen end of the week for any particular reason. We could go, a direct week later and just in the morning. Yeah, but this is a very, as you could tell when you arrived today, a busy room because of its technological capabilities. It gets booked up way out. So,
do we already know what potential available time slots for a second, whether morning, evening?
The only one that I remember is that the immediate following next day had ample, the whole day was available, the 9th.
On the 9th?
I'm available on the 9th.
I am too.
I could do both,
I can do
or
the 9th.
either.
We didn't want to suggest that to make you come Thursday night and then
then come the
immediately
next
come
morning.
back on Friday. But
Yeah,
if you're comfortable with that,
I'm
then
fine with
that
that.
works
For
for us.
mornings, for mornings, Friday's by far the best morning for me.
And I would be available then and could chair to finish out the meeting.
So what time?
Yeah.
In 2020, we started at 9 o'clock. I think that that's a pretty standard, business.
We, for the Thursday meeting, should we just say set a stop time of 9 p.m.?
Oh. Yeah.
You could do that.
Yeah.
May I suggest, just thinking of the poor applicants, if we can say Thursday, we're going to do the first X number of
Right.
cases?
Yeah.
And
Yeah.
Friday, we'll do the rest?
Right.
That's probably better.
Let you guys figure out how bad you think each conversation's going to be to figure out which
Set
day
the
to put it
agenda
on?
appropriately.
I don't know if we can assess that
Well, your best
accurately.
guess.
Yeah. It might still be better to let them know, hey, you're going Friday, you're going Thursday.
Yeah.
Yep.
There's
And-
13, you said?
There are 13.
Yeah, so we split up 7, 6, 6, 7.
And you said Friday is open all day?
From when we looked the other day, it was.
I mean, maybe we want to look at, just knowing that if, just in case Thursday blows up for that first set, having Friday not start at 9 a.m., but start after lunch, like 1. So it's a 4-hour window.
That's also kind of why I suggested maybe just setting a hard stop time on Thursday. But, I mean, hopefully you'd be able to get through 6 to 7.
Yeah.
Yeah, I think we can do that.
We did 6 tonight, right?
Yeah. 1.
Let's see.
Well,
No,
5
5.
plus 1.
Yeah.
We have,
And 2 of them were a little long.
A little.
so we might be able to orchestrate this a little bit. Typically, the way the cases are heard is in the order they were submitted. That is not a legal requirement.
Okay.
So we could potentially look at cases that we think are likely to make it through the process quicker than others, or split it half and half, so we're not waiting all our heavy cases at one particular day.
I vote for that.
Kind of try to figure that out. And it may also be subject to the applicant's availability. People are used to coming to these meetings at 5 p.m. on a Thursday, not at 9 a.m. on a Friday. Many people work at that time. So we can convene as staff, reach out to applicants, try to figure out what will work best, and come up with a plan. But what I'm hearing is you want to set a time or a potential caseload for Thursday night, so we can estimate that up till about 9, 4-hour meeting, and then we'll be booking this space for the next morning as well.
Okay.
And we would need Rob would chair in my place on that Thursday, but then obviously we would need an alternate for Rob.
Yes, and I believe there's a case where Curtis is going to need to recuse as
Yes.
well. So the committee alternates may also need to get involved in making sure they're available. We can always move forward with 3. 3 is a quorum, but it's required that you all vote unanimously for things to be approved if that's the case. So we try to avoid it.
And if you take the case where I need to recuse and make sure it's on the Friday where we have our chair, the problem goes away with the alternate.
True.
That's a good point.
And they're both people who work a business day who would be representing that case, so they would not have, it would be part of their day. That would be a good thing.
Noted.
All righty then.
Okay. Any other discussion? Hearing none, we are adjourned.
Thank you.
Thank you.
Staff, city attorney.